Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good morning.
Good morning, Your Honor. Assistant Public Defender Kasim based on behalf of Mr. Mbaye Ndaye. Is he here? I have not spoken with him, Your Honor. Mr. Ndaye? Your Honor, I have not had any meaningful contact with him, unfortunately. Was going to be asking for an adjournment. There is an offer. He did pay about $3,000 to get out. There was an agreement between the Attorney General's office and I, but I have not been able to reach him.
He's not here. How much is currently owing on the child support council?
So, Judge, my understanding is that the defendant posted the bond. It has not yet showed up in the child support system, but his current arrearage, Your Honor, is $20,287.86. I'm wondering.
You said 20. I'm sorry. You 20, said 20,000.
$20,287.86.
Thank you,
Judge. I know you have a mechanism to have those bonds. Do we know whether they're processing that bond over to the child support case?
They should. Yes, our mechanism is that the order would read to pay that bond over. And I think that has, I just want to make sure that the bond form indicates that. And it does, to send over to circuit court. So he's paid about 3,000, a little over 3,000 of that amount.
That's correct.
So it's about 17,200 that's still owed.
That
so
would be
bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $17,200. That's cash to be paid to the circuit court if posted. That warrant will issue immediately.
Thank you, Your Honor.
And Your Honor, will that be an immediate bench warrant? And do you need the AG to prepare and submit it, or will the court handle that?
No, we will handle it, and it's an immediate bench warrant.
Very well. Thank you very much, Your Honor.
All right, thank you. Court does call the case of People versus Devontae Davis.
That for the people.
Morning, Your Honor. Alex Warren, Green on behalf of Mr. Davis. Mr. Davis, can you state your name for the court?
Devontae Davis.
Okay, thank you.
Your Honor, at this time, we are asking the court to set this matter for preliminary examination.
And all discovery is complete.
I believe so, Your Honor.
And which one are we on, July 12 years out?
Oh, I'm sorry. It's a week from July 1st.
I thought so. People have their witnesses available July 1st. Preliminary examination in person will be set July 1st, 2025. 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Alan Ballou.
Good morning, Judge Lawrence H. Margolis and on behalf of Alan Ballou. Alan, please state your name.
Alan David Ballou.
Judge, this is a referral, we hope, to the Veterans Court. He has been accepted into the court, and we are prepared to go forward with a plea today. If Your Honor will take it, he has been advised of his rights. He has signed a waiver. He is also prepared.
What is he pleading to?
Disorderly.
I don't know. Your Honor, I don't know if for Douglaston people, Your Honor, I don't know if Your Honor had a chance to sign the referral and if that paperwork.
I have the referral that I will sign off on, but I don't have a plea form. I don't have anything.
Then we aren't ready for it, because we needed you to sign it. So that's what we needed.
Yeah, that was the one thing I was waiting on. Was hoping we could do it this morning, but I don't obviously mind passing.
Do what this morning?
Sign the plea form. That was the only thing that was not prepared.
I don't kind of need that.
I was hopeful that Ms. Douglas could,
Okay, what am I doing? Because otherwise I'm just gonna do what I'm gonna do.
I have an email at 9 a.m. with maybe the information that you're looking for. I don't know.
At 9 o'clock this morning?
Yes, I have not reviewed it over. So Your Honor, he was trying to get him referred to Veterans Court. I had not received confirmation that he'd been accepted, and that's why I didn't do the plea form, because he needed paperwork.
No, I got you, because I just signed off on the referral. So I can't really do anything.
and I apologize, Your Honor, I was under the assumption that the emails that I had provided from Mr. Graveline stating that he had been accepted into the court and that this was going to be pled today was going to be sufficient, but
Probable cause in this matter will be adjourned June 26, 2025, 9 a.m. Bond will continue. You guys get your stuff together and then I'll deal with it.
Thank you, Judge.
Court does call the case, People versus Larry Hickman.
Judge Kennedy, people, Your Honor.
This was the.
Yes.
Good morning, Your Honor. Student attorney requesting Andra Savvy requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinruli, representing Mr. Hickman, who is present in person today.
Permission to practice is granted.
Thank you, Your Honor.
I
Your
guess the
Honor.
first thing we need to take care of is there were additional counts added, counts 3 and 4. I think we got the counts straight. Have you reviewed those with your client?
I believe Ms. Ikiri Akinruli has reviewed those counts with Mr. Hickman. No. The new counts were they reviewed with you yesterday? No. No?
Where is Miss Akinruli then?
I'm not sure, Your Honor. I believe she may be in another courtroom at this time.
Well, has anybody gone through the other counts with him that were authorized? Or you don't know? I'll take that as that I don't know. Huh?
Yeah, I apologize, Your Honor. I cannot provide an answer to
You
that at
take
this
it
time.
back. I'll pass the matter. We'll have to bring him out later.
Okay.
I have to go through those other counts. Court does call the case of the People versus Brandon Clemens.
Good morning, Your Honor. Attorney Jonathan Paul for Mr. Clemens.
Mr. Clemens, can you state your name, please?
Yes, sir, Brandon Clemens.
And I'm gonna. That's what. My God.
It's underneath that.
Okay, thank you. All right.
I wasn't sure you were going to be able to do it.
That's the one report that I got
Yes.
last minute. All right. I have before me a plea form that indicates that the defendant is going to be pleading guilt. Well, is he going to be pleading guilty or no contest? Because otherwise I've wasted my time reviewing a plea.
Your Honor, he's pleading guilty.
Pleading guilty to the charge of operating while intoxicated with an occupant less than 16, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that
Yes.
correct?
Yes, sir, that's correct.
Yes, Your Honor.
Mr. Clemens, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes, Your Honor.
State your name again for the record.
Brandon Clemens.
Put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated with an occupant less than 16. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right. And understanding all of that, well, and I'll also indicate to you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge. Need a name? Before Judge Perry in the 15th District Court. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, sir.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Pardon?
I currently have a sober breathalyzer.
You're not,
Right. Are you under the jurisdiction of any other court, sir?
No, Your Honor.
All right. Have you ever been to prison for longer than a year?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
All right. And you understand that if you commit any type of misconduct between the time of this plea and the time of sentencing, that you would not be entitled to withdraw your plea unless allowed by the court for a good cause. You understand that?
Yes, Your Honor.
You also understand, sir, that if you do commit misconduct during that time, the sentencing judge would not be bound by any recommendation or evaluation.
Yes, Your Honor.
Is counsel aware of any other pleas, inducements, or threats that have led to this plea?
no, Your Honor.
Counsel, I didn't hear you.
No, Your Honor.
All right. Sir, on the date of April 3rd, 2024, at the location of Liberty Street near Maple Road in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I had drank heavily the night before, and then the day of that morning, I had about 2 twisted teas. I think my blood alcohol was mostly from the night before of me drinking heavily.
Were you stopped by the police or was there an accident?
I was stopped by the police. There was
Why did they stop you?
I did bump a little bucket inside of the store, but they stopped me because of the driving that they had witnessed.
Are you disputing the right of the police to stop you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
And were you taken to the station or the hospital?
I was taken to the station, Your Honor.
Was there a data master or breathalyzer test of some type?
Not on my end, Your Honor. They took me to the police station, and then later they took me to
Counsel,
the
was there a
hospital.
breath test or a blood test in this case?
Your Honor, it was a blood test of
I have the
0.24.
labs.
Did you take a blood test, sir?
Yes, Your Honor.
What were the results of that blood test?
0.24H, Your Honor.
.248. Sir, do you have any reason to dispute those blood test results?
No, Your Honor.
Was there an occupant in that vehicle
You broke up, Your
besides
Honor.
you?
Yes,
Pardon?
there was another occupant in the car, Your Honor.
Who was that?
That was my girlfriend's son.
And how old is he?
He is currently 6.
At the time, how old was he?
He would have been 5 years old, Your Honor.
Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea. 2 count 1 is dismissed. The pre-sentence investigation and screening and assessment is ordered at 15th District Court. Sentencing in this matter will be July 14th, 2025, 8:30 before Judge Perry.
Thank you very much, Your Honor.
Bond with its conditions will continue. Thank you.
You can sign off, Brandon.
Thanks.
Court calls the case of the people versus Michael Patterson.
Cedric County, the active people, Your Honor.
I have 2 cases. Second, really? Hang on a second.
Good morning, Your Honor.
Pardon?
I said, good morning, Your Honor.
Not really, but thanks. Good morning to you.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Patterson. Today is the date and time set for the probable cause conference, Your Honor.
Yes, in both matters.
Set up a preliminary examination.
What's that?
Set up a preliminary examination covers the officers.
Oh, that's from the prosecutor?
Yes.
Look, I go to hospital. So today, I would like to be concluded from this situation, in this case, just to be further admitted into the psychiatric hospital. He already ordained that.
We'll do that as part of the bond.
All
Your
right.
Honor, today, there are no offers from the prosecution. My client will respectfully request that this matter be set for preliminary examination. We'd also like to address the bond at the appropriate time.
You want preliminary examination in both cases, sir?
Yes, please.
To your knowledge, all discovery is complete.
To my knowledge, yes.
People have their witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor. As to bond, we're asking for a modification. My client indicates that he has already been determined to be released to,
I'm sorry?
To Havenwick, Arbor Hills, Havenwick Hospital for psychiatric treatment.
Arborwick, Haven Hills Hospital. We're asking that his bond in these cases allow him that similar release to, what's saying the name of it again, please?
To Auburn Hills, Havenwick Hospital.
Auburn Hills, Haven.
For treatment?
Yes, please.
And you say he has that in his other cases, or?
Yes, the last time I was here, that's what I was before you, Judge Simpson, and
Yeah.
you ordered for me to go there.
I think I ordered release to inpatient treatment.
That's right. That's what I want.
But I think did we already order it?
Well, it sounds to me like.
On my last court date, that's what was that was ordered by you personally.
Okay, I don't have an order. If it's a release to inpatient treatment, I am not going to have an objection whatsoever. So where's Ms. Yagi? Ms. Yagi has an order that she has prepared that probably all of the public defenders should use. That I'd be more than happy to sign off on, that I've signed off on for the last 5 to 10 times for her.
I know Ms. Yagi will happily share.
Thank you, Ms. Yagi.
Because we are one happy family.
I don't know about all that. All right, so at this point, what I'll do is his bond will continue. And once I receive that order, I'll sign off on it.
Thank you very much.
All right, thank you.
Thank you, brother.
You're welcome.
Trying to whip him into shape. Court calls the case, People versus Mary Collins.
Andrew Banner for the people.
Good morning, Judge Cabral, on behalf of Mary Collins, who is approaching the podium. And Mrs. Collins, please introduce yourself to the court.
I'm Mary Collins.
Thank you.
And Your Honor, today's the date and time set for probable cause conference. I have spoken to Prosecutor Banis. We are working on a resolution. I do have a adjournment form for the court's file.
Probable cause conference in this matter will be adjourned to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Court does call the case, People versus Lakita Roberts.
Andrew Banner for the people.
Have you start working.
Hannah Mackey on behalf of Ms. Lakita, who's approaching to my right. Please state your name for the record.
Roberts.
Your Honor, we're respectfully requesting an adjournment. We believe that we could discuss a possible global resolution in her circuit court matter as well.
So she has things in circuit court.
She does, Your Honor.
And when's her next date in circuit?
I don't know that one.
You're gonna do a global resolution. Don't you think you should know that? I'll wait.
Your Honor. I see a case, according to X jail, a circuit case scheduled for 6/25, June 25th.
June 25th, Your Honor, is the date.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond continue.
Thank you.
Court calls the case of the People versus Bianca Rao.
Andrew Banner for the people.
However, on behalf of Ms. Rowell, who's approaching the podium. Ms. Rowell, please say your name for the record.
Bianca Rao.
So, thank you, Your Honor. So we are, today is the date and time for probable cause conference. We have worked out a resolution. I've provided documents to the prosecutor, Mr. Banis today, and I have a few more that I'm going to email that Ms. Rowell provided for me today. We just need to have first APA, Burton Harris, look at these documents. So we are asking for a brief adjournment, hopefully the last.
Probable cause conference will be adjourned July 3rd, 2025.
Thank you, Judge.
9 a.m. Bond continued. Court calls case People versus Thomas Vasher.
Andrew Banner.
And Alex Warren Green on behalf of Mr. Vasher. Mr. Vasher, can you state your name for the court?
Thomas Vasher. Are we gonna get breakout room or something?
Oh, Your Honor, I went to the jail last night and
Yes, you did. He wasn't there. He's in the hospital.
he has been transported to the hospital.
Yes.
So I'm asking for an adjournment. The people generously did extend an offer. I want to discuss that with Mr. Vasher. And if I may ask on the record, Mr.
Now-
Vasher, do you anticipate when you'll be discharged and returned to the jail?
No, actually, they just talked to me and I plan on staying here. They need to run
Okay, well,
different tests.
Mr.
and see what
Vasher, call the
legs are-
public defender's office if you can. And Your
Well,
Honor,
how
I'm
come
respectfully asking
breakout room and
for
you
an
can-
adjournment.
Or can you address my bond at least? Because I'm here on my bond's been violated because you guys.
Mr. Vasher,
court date while I was out.
Your Honor, I'm requesting an adjournment to the next available
well,
date so I can talk
to
to
address
him.
my bond. I'm asking you that.
I'll give him an early date. That way you can go talk to him and see exactly what it is his complaint is. June 26th, 2025, 9 a.m. Bond continues.
Thank you, Your
I'm gonna
Honor.
I want a new counsel.
Court calls case People versus Julius Holston. That's on.
Andrew Banner for the people.
Good morning, Your Honor. Edward Rodriguez on behalf of Julius Holston.
Good morning, Your Honor. Julie's host.
Your Honor, there was a resolution that was worked out this morning. It would be a no contest plea. I have a plea form if the court's able to allow that. Otherwise, we'd be asking for an adjournment.
No contest. I haven't even read a report.
I
They're
understand.
supposed to get to me at least 24 hours. I don't mind doing the work, but I'm not gonna do it on this day.
Okay.
So I'm gonna put it over and then I'll take your plea.
Okay.
But I'm not gonna do it. I'm not gonna doing that today.
That sounds like a plan.
Probable cause conference, June 26, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Demarius Tubbs.
Andrew Bennett.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051 on behalf of Demarius Tubbs. Mr. Tubbs, please state your full name for the record.
Demarius Tubbs. All right, first order of business is I need a substitution of attorney filed. Mr. Martell, I'll let you go ahead. I realize you filed an appearance, but I think you know the court rules require a substitution of attorney.
Yes, Judge.
All right, what are we doing today on this?
Judge, it was my expectation that charges would be filed federally by now. I have not received any. So Judge, discovery is complete. I'm asking for an examination date, please and thank you.
I didn't hear any of that. You need a better microphone.
Forgive me, Judge. Discovery is complete. We're asking for a preliminary examination date.
People have their witnesses available July 1st.
We will do our best, Your Honor.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Always a pleasure. Have a great day.
Court calls the case People versus James Chandler.
And is on behalf of the people, Your Honor.
And good morning, Your Honor. If it please this honorable court, Brandon Bird on behalf of James Chandler. Mr. Chandler, can you please state your full name for the record?
James Chandler.
Where's the rest of his pants?
I was at work. He was at work, Your Honor.
Really?
And that's and one thing about it is my apology. I had told him it was going to be 2 p.m. And once I seen he was on the 9 a.m. docket, I called him later. He hurried up and got up.
And so what, his pants weren't ready or what?
He probably didn't have any pants where he was.
I see. Oh. Okay.
But now
it won't happen again, right?
Never again.
Yeah, okay, go ahead.
Okay, today we're gonna.
So that's not your fault, it's his. Yeah, don't worry about it.
It is.
I know, everybody knows it's your fault.
I take full
All
responsibility. Now, we're just asking for a slight adjournment because the prosecutor needs to check to see if the body cam has audio, Your Honor.
That's correct, Your Honor. Media's been provided, but it's my understanding that Mr. Bird's media doesn't have audio, so I need to check in if there is audio on the videos.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue.
Okay.
Fill out a green form?
I did, Your Honor.
All right, yay.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Philip Brown.
Regardless of people.
Okay, where's Burgess?
He's here.
Good morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Philip Brown.
All right, what are we doing?
Your Honor, this was a reissue. I have had discovery for some time, so we're requesting an exam in this matter.
People have witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Barr.
Judge, may I briefly address the issue, bond?
You may.
Thank you, Your Honor. Your Honor, bond is currently set at 250,000 cash surety in this case. Understand the serious nature of the charges, but the allegations are that the complainants in this case ran up into my client's girlfriend's house where he was staying. The police report is somewhat vague on whether the incident occurred outside or inside the residence, but be that as it may, Your Honor, on my client's actions, we do take the position that my client was acting in self-defense of himself, his girlfriend, and her home. And all three witnesses on the case before didn't appear at the last exam, Your Honor, after speaking respectively to their counsel, which they needed appointed because of their potential Fifth Amendment issues. So based on that situation, Your Honor, I think that the bond should be lowered, maybe 50,000, 10%. My client didn't want me to ask for a PR bond. I know the charges are serious, but I do think under the circumstances, the bond's excessive. Thank you, Judge.
Response.
I believe that the bond is appropriate. The report is not vague about where this took place. The allegation is not that these people ran up in the house, it's that they did go to the house, and that this occurred outside, and that a neighbor who was uninvolved witnessed part of this, and it was the reason she was able to witness it is because it happened outside. And so, Your Honor, there's the allegation that he shot at 3 different people in the front yard. As far as the witnesses, 2 witnesses that were able to be contacted for the exam when this was initially issued did want to move forward. They were not able to come on that date. And so the people were unable to get an adjournment. And that's why there was a dismissal and immediate reissue. It's not that they didn't want to move forward. So, Your Honor, we do believe that this bond is appropriate.
Who was this case originally before?
Judge Washington? Yes. Judge Washington, I believe, Your Honor.
But no testimony was heard?
Correct, Your Honor. We've adjourned it a few times for them to
Then
speak
I'll
to
leave
counsel.
it. I'll leave it before. All right. Anything else?
Your Honor, only that the 3 people that came to the house came uninvited, and they were all, this was over a dispute, so they were coming there, obviously.
Were they armed?
Yes, Your Honor.
Your Honor, there was one individual who admitted to having a firearm. However, he is not accused of trying to shoot him.
Only accused of bringing a gun to a stranger's house without permission.
Yeah.
I believe there was an AR-15, Your Honor. That's a semi-automatic rifle.
Have a firearm.
But there are 3 felony firearm charges here at the 3 in possession of the allegations that he's a prohibited person, so he shouldn't have a firearm or ammunition. And then I have 1, 2, 3 counts of assault with intent to murder and assault with intent to do great bodily harm less than murder and carrying concealed. All right. Anything else from either side?
Your Honor, there was one minor, there was a no contact issue to his girlfriend, Latrice Hargrove, when he was rearranged on this case. That had been lifted last time. It was a confusion as to that. She's just his girlfriend, not a complaining witness to the case. I just asked that he be allowed to have contact with her. She'd be a defense witness in this case.
Any responses to no contact?
Your Honor, she is a witness in this case. I believe that the no contact was issued because part of the conflict is supposed to have been based on allegation that Mr. Brown had done something to her daughter, but I believe that discussion.
Okay, I'm not going to change the no contact. I'm going to leave that where it is at this point. I'm also going to deny the defendant's motion for a bond reduction. Bond will continue. Thank you.
So if you need another copy, go. Okay.
Let's call the case of People versus Leorn McEwen.
Yes, Your Honor. Please, this honorable court again, Brandon Bird on behalf of Leorn McEwen. Mr. McEwen, can you please state your full name for the record? Please.
Thank you. All right, what are we doing?
I would really like to get this resolved, Your Honor. But if Sister Prosecutor doesn't believe that we can get this resolved, then we're gonna set this matter for exam.
You have all the discovery.
I do have all the discovery.
People have their witnesses available to first. You need to take, sir, you need to take your hand out of
Oh,
your
I'm sorry.
preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue.
Just for the record, the offer has been that if Mr. McEwen could provide proof that he could drug treatment the date of offense, that would be offered as use, however, that apparently is not.
I say anything? I've been in treatment for 5 years. This case is 5 years old. So is there any way we could adjourn this matter, Your Honor, to provide Sister Prosecutor?
I passed all my drug tests, every one of them.
I need a green sheet. Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Thank you. July 3rd.
Okay, sir. Thank you.
Thank you, Your Honor. Thank you for your patience today,
Thank
too.
you, sir.
What?
Thank you for your patience today.
Oh, no, that's really not in the cards. Thank you. Court does call the case, People versus Todd Rayberg. Now you get it. All three
Morning,
cases.
Your Honor, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Rayberg. And Your Honor, I do have some paperwork here. I just had it. Mr. Rayberg, could you state your name for the court?
Todd Rayberg.
I swear I had it, Your Honor. Here it is. I am requesting a brief adjournment. One of these cases is very new and I didn't have the police report yesterday when I met with Mr. Rayberg. I'm also submitting to the court a proposed release to treatment order if the court would consider signing it.
Any objection to release the treatment from the people?
Your Honor, there's no objection.
I'll sign that order. And then I'll grant the adjournment in this matter. On the 6th, which is going to be the day from where you want the 3rd.
I think probably the 3rd, Your Honor.
Good enough.
Thank you.
So probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will.
Thank you.
Okay. Court does call the case, People versus Adam Barry. This is the one.
Oh, different.
No, it's one.
Right, the people put their appearance on the record. Joe Simon, you did, right? Sorry, Joe Simon on behalf of defendant Mr. Barry, state your name.
Adam Barry.
All right. You need an adjournment in this case.
Yes, I'm going to supply some mitigation documents to the people in support of a request.
think July 10th was.
I will be back, Your Honor, but you may be seeing too much of me on that particular day.
Oh, I'm seeing too much of you every day.
So either the 10th or the 17th, but I have, sometimes the court gets mad when he sees too much of me.
July 10th, 2025, 9 a.m. Bond will continue.
Thank you. Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Mohammed Dar.
Say it again. Yeah, actually.
Assistant Public Defender Costinville based on behalf of Mohammed Dar, who is present to my right. Mr. Dar, could you state your full name for the record?
Mohammed Hassan Dar.
Thank you. Your Honor, today's the date and time set for probable cause conference. At this time, there is no offer, so we'll be requesting to set this for a preliminary exam at the soonest available date.
You have all discovery.
To my knowledge, Your Honor.
People have their witnesses available the first
Do our best, Your Honor.
preliminary examination in person, July 1st, 2025,
Your Honor, may I address bond when
9
appropriate?
a.m. Yes,
Your Honor, my client is requesting a PR bond. He has two jobs on the outside that he would like to keep. This is in a group home. He supports his mother financially by sending her money. He also has some personal matters that he needs to be taking care of on the outside. I don't believe he's a further danger, Your Honor, if the court is inclined to give him a GPS tether or put in the no contact, no go to orders. He's willing to do whatever the court deems necessary, Your Honor.
strong.
I object to any modification of bond at this time. My understanding, Your Honor, is that the defendant was currently on bond at a case out of the 15th District Court. Failed to appear at that case while he was hospitalized, which is where this offense took place. In this present matter, the defendant assaulted a nurse by grabbing the right breast, and she was placing a blanket on him. I object to the modification.
Well, we certainly understand how serious the allegations are, Your Honor. As I said, my client is open to any no go to, no contact orders, anything the court deems appropriate. We don't believe he's a further ongoing danger to the community nor a flight risk, Your Honor, at this time.
His bond is set at this point at $1,000 cash surety. So I think that's appropriate given the allegations in this case. Motion for bond reduction is denied. Bond will continue.
What was that date, Your Honor, for the?
July 1st.
Thank you.
Thank you, Your Honor.
July 1st before Judge Barr.
Thank you, Your Honor.
Did I put that in there? I think I did. Double check it. Yeah. Court does call the case People versus David Witherspoon.
Ready, Your Honor. Andrew Bannister.
Your Honor, Joe Simon, on behalf of Mr. Witherspoon, is making his way to the podium. Mr. Witherspoon, state your name, please.
David Witherspoon.
Your Honor, may counsel approach?
Yes,
Thank you, Your Honor.
court will pass this matter. Recall it later. Court does call the case of the People versus Mark Hubbard.
Ally Zend on behalf of the people, Your Honor.
Anna Mack on behalf of Mr. Hubbard, who is approaching. Please state your name for the record.
Mark Hubbard.
Your Honor, we're respectfully requesting an adjournment. We just received discovery and have yet to go over it with the clock.
Is anything else holding him or?
I don't believe so, Your Honor. I believe
This
it's
is
just
the only thing holding it.
correct.
All right, probable cause conference, June 26, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Thank you.
Court does call the case of the People versus Joel Jones.
Good morning, Your Honor. David Burgess on behalf of Joel Jones. who does not appear to be here.
He's not here.
No.
Got it. Joel Jones, you were just appointed on this case.
Yes, Your Honor. So I don't have a contact number for her at this time.
And well, the reason I'm asking, I think she's been on bench warrant status.
She was, I think I appeared on Zoom on the 20 case, Your Honor. There's two cases, I believe.
Right.
Yeah. And I appeared on Zoom that day and I gave her my information, but I did not receive a call from her.
Bench warrant will issue for defendant's failure to appear. In each case, bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. You can get that one. You can get this one. Court does call the case, People versus Javante Jackson.
Ally Zen on behalf of the people.
I have anybody that lost.
I can't see, I'm so sorry.
They are not. They're coming. Javante Jackson. We have Jackson.
Assistant Public Defender Sandra White on behalf of Javante Jackson.
State your name, sir.
How you doing, Javante Jackson?
What are we doing?
Your Honor, we're asking for an adjournment in this matter. Apparently, there are some jail calls I was just made aware of that we need to review.
Your Honor, I'd like to address that.
All right. I'm gonna need a green sheet. All right, yes, Esteban.
Thank you, Your Honor. It's come to my attention, this defense has made 16 complete calls to the victim this week, as well as 142 attempts to call her. These calls are extremely concerning. At the beginning of the call, the victim tells him she wants him to stop contacting her, that she's going to come to court. He continues to keep calling her, as well as having a third party reach out to her. He says to the third party, "You want to do me a solid?" Third party says, "What's that?" He says, "Pull up on that bitch. She's gonna cry to you. She's gonna do all this crying shit to you. Just pull up on her for me and be like, yo, don't cook." Because yesterday I talked to her and she kept going on about testifying. So I have extreme concerns that he's not only reaching out to the victim, but also third parties to contact the victim on his behalf. And would ask that his phone privileges be revoked.
Any response to that?
Yes, Your Honor, I would ask, first of all, we need to review these calls, but that the phone privileges only be revoked to that certain number. Mr. Jackson needs to call his parole officer, so we are asking for the calls to only be revoked to that certain number.
You need to do what?
Calls, have phone calls with his parole officer. We are trying to arrange certain things.
But the calls that the people are talking about aren't parole calls to his parole officer.
That is correct, Your Honor.
Probable cause conference will be adjourned to July 3rd, 2025, 9 a.m. At this time, pending a hearing or request for a hearing, defendants' phone privileges are hereby ordered revoked.
Thank you, Your Honor.
Bond will continue. That was for you. Court calls the case, People versus Joseph Bailey.
Ally Zen on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Bailey. Could you state your name, Mr. Bailey?
Joseph Bailey.
You forgot his pants too?
Oh, Mr. Bailey, you gotta wear long pants in court moving forward. Your Honor.
Pardon me about that.
Pardon?
Say pardon me about that.
Okay.
We're asking the court to set this matter for preliminary examination. And my client does have a request relative to his bond conditions.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 1st, 2025, 9 a.m. before Judge Perry. Esteban.
Thank you, Your Honor. Mr. Bailey is currently on a hot zone tether. He's asking the court to consider removing that requirement. He is a moving truck driver. He's a soccer coach. And my understanding is that this case involves allegations of electronic communications only. So, Your Honor, I believe the no go to and no contact order are sufficient.
But it's an aggravated stalking that may begin with electronic communication.
Understood, Your Honor. I just wanted to make the request.
Response?
Your Honor, I would object to any bond. This is an aggravated stalking when she violated a people. I have concerns about the victim and would ask that the tether remain on, given that he already violated a court order to initiate this case.
Well, okay. Motion for bond reduction or bond modification is denied. Bond will continue with its conditions. All right, thank you.
Thank you, Your Honor.
I have some. Court does call the case People versus Chad Jones.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Jones, who's approaching. Mr. Jones, could you state your name for the court?
Chad Jones.
And Your Honor, I did submit, or I did fill out, not submit yet, but a green sheet. Mr. Jones is seeking a global resolution. I am asking for another adjournment. We need some paperwork from some other jurisdictions, but I am asking for a 2-week adjournment for
2 weeks. You'll be able to get everything you think in 2 weeks.
I'm not sure, but I think it makes sense to just ask for 2 weeks at this point.
Any objection?
There's no objection. Your Honor.
Probable cause conference. So, well, I have 10 days out, but you want July 3rd date?
Do you have a preference? Okay, that's fine, Your Honor.
All right. July 3rd, 2025, 9 a.m. Bond will continue. Court calls case of People versus Grace Brenner.
And then on behalf of the people.
Assistant Public Defender Sandra White on behalf of Grace Brenner. Your Honor, I have tried to contact Ms. Brenner. She works through a worker and the phone number, I think with Avalon Housing, I'm not sure. I don't believe she's missed any court dates, so I would ask for an adjournment.
Your Honor, at this time, I wouldn't object to the adjournment. Ms. Brenner normally appears on Zoom, and Ms. Apple is normally covering her case, so there may have been a slight with Ms. Apple being out this week.
Really?
I believe so, Your Honor. She has been at every previous court date.
And I thank Ms. Zenda. We did talk about that, and she said we did.
You two?
And
So
we're
you
hoping
two
that,
rigged this whole thing for an adjournment?
yes, and we're hoping you agree.
And Ally signed on?
Yes, she's nice. Sometimes.
That implies
Sometimes.
that implies others aren't. Who are you talking about?
We're not going to mention any names.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. without objection. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Paris Lester.
Good morning, Your Honor. Kirma Dadish on behalf of Mr. Lester. Lester, can you please state your name for the record?
Yes, Paris Lester.
Okay, so Mr. Deuce, let me explain something about what she did. So she didn't know what a shortstop was the last time we were here.
I have a diagram.
Hold on. I then sent you a baseball diamond. With yeah, you got it.
I have a diagram for you.
Uh-oh.
For a game that you won't understand.
Oh, no.
So now she wants to play games with me.
That's what baseball looks like to me.
Wow, I'm sorry.
I appreciate that. It's Yellow's turn.
I don't even know what that is. That's what baseball looks like to her?
Looks like a house.
Okay, so I sent her a baseball diamond with all of the positions listed and their number next to them. She's showing it. The response I get back, I was trying to help her, was she called me a troll. I'm just
I never
Just,
said.
I,
those
no, I'm just
words.
pointing that out what you did.
I
I
never
just,
said.
no. You want an adjournment?
Yes,
Yeah,
please.
you may.
There are pending charges that are waiting to be authorized, so we are adjourning.
Additional charges against this defendant?
No, never. Yes, again.
So where are they do we know where they are in the system and how?
Your Honor, we have the warrant request, but I have to go through them. There's 3 or 4 of them.
There's 3, okay. And is this then the only thing holding him at this point? No?
No.
All right. Well, what I'll do then is I'll adjourn it out. Let's see where we are. I'll just go 2 weeks out, or basically 2 weeks out to July 3rd, 2025.
And for the record, Your Honor, we are, on his other cases, we are potentially working with CMH.
On
right,
those.
yeah, okay,
Got it.
thank you.
All right. And at this point, it's bond will continue. All right, thank you.
Yeah, please.
Good. Oh. I don't even know what that name is. That's what she gave me. It's some voodoo stuff. Court goes case people versus Dave Ellington. See, I was trying to help her out.
Ellington? And Jennifer Douglas.
You know what a shortstop is, right? Oh, okay, never mind.
Welcome back, Mr. Allen.
Wow. She said, welcome back. She did? Did she miss you? Huh? Why did she say that?
Well, I
There's
just
something
was
there.
acknowledging that.
No, something's up.
Your Honor, we are requesting a 2-week adjournment for mitigation purposes.
Any objection from the people? Probable cause July 3rd, 2025, 9 a.m. Bond continue.
July 3rd, 7-3, 9 a.m.
Court does call the case of the people versus Tyler Redmond. Thank
you.
Good morning, Your Honor. Intern Malika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender Lauren Brown.
Oh. So bald head. Permission to practice is granted.
Thank you, Your Honor. Appearing with and on behalf of Tyler Redmond, please state your name for the record.
Tyler Redmond. Thank you, sir. All right, what are we doing?
At this time, we are requesting an adjournment to be assessed for the Drug Circuit Court, which is set for June
The
20.
Drug Circuit Court.
The Drug Treatment Court. Yeah.
Circuit Court. I don't know what that means.
Circuit Drug Court.
Okay, go ahead.
It is set for June 26th, so date after
So
that.
they would be, they have their meeting on the 26th.
Yes.
Okay. Any objection from the people?
No, no.
July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. What's she do? I haven't left to sign. Trying to be fancy. Oh, you got it out there. Court does call the case people versus Latosha Griffin.
On behalf of Ms. Griffin, can you say your name for the record?
Latasha Griffin.
Latasha Griffin.
Your Honor, we are going to be setting this for preliminary examination. Please.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the first. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond continue.
Thank you.
Court does call the cases of the people versus Leo Stringa.
Andrew Bamish for the people.
Hannah Mackey on behalf of Mr. Stringer, who is approaching to my right. Please state your name for the record.
Leo Stringer.
Your Honor, we're respectfully requesting an adjournment to write up a plea offer form.
To do what?
We need to write a plea form.
Is this the only thing holding him?
I
Why is every question I ask her a mystery?
Feel the same way sometimes, Your Honor.
Huh?
Said I feel the
Your
same
Honor,
way
it's
sometimes.
Wow.
It's not the only thing holding him in this county.
Pardon?
He has other holds in other counties.
Other
But in
places.
this
In
county,
this
it's
county,
only-
this is the only.
Probable cause conference July 3rd, 2025, 9 a.m. Bond continue. Did she give me a green sheet?
Oh.
Do you have a green sheet? Or you're just gonna hold it?
No, I'm gonna fill it out.
Oh, you haven't even filled it out. Okay, so the correct answer to that would have been no.
Green sheet. Technically, I have a green sheet.
This is like riding that bus. Demetrius Griggs?
Ally said on behalf of the people, Your Honor.
Stephanie Can on behalf of Ms. Griggs. Ms. Griggs, could you please state your name for the record? Demetrius Griggs. And Your Honor, we are just setting this for a preliminary exam.
Discovery complete.
To my knowledge, Your Honor, yes.
You will have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination, July 1st, 2025, 9 a.m. That's before Judge Barr.
7 a.m. before, it's here.
I understand what.
Yes.
Bond
9
will
a.m.
continue.
9.
Thank you.
Thank you.
Court does call the case People versus Larry Hickman recall.
People, Your Honor.
Good morning, Your Honor. Assistant Public Defender Chinazi Kyriakin-Woodley. On behalf of Mr. Larry Hickman. Mr. Hickman, could you state your name for the record, please?
All right.
Your Honor, today's date and time set for a probable cause conference in this matter. The people did send over an amended complaint. I think he would need to be arraigned on the additional
Yes, he needs
charges.
to be arraigned on counts 3 and 4. So you waive their formal reading.
We do waive formal reading of that, Your Honor. We stand mute asking the court to enter a not guilty plea on Mr. Hickman's behalf.
All right. Been enabled to waive formal reading, standing mute to counts 3 and 4. Court will enter a not guilty plea.
Thank you, Your Honor. And in regards to the probable cause conference, we'd like to set this matter for preliminary examination, Judge.
You want this set for the prelim?
Yes, please.
And you're satisfied with discovery, even with the added counts?
Yes, we are, Judge.
All right. People have their witnesses available the first. Preliminary examination will be set July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Thank you, Judge.
Court does call the case of the people versus Alicia Henderson.
Assistant Public Defender Chinazi Kyriakin-Woodley, Your Honor, on behalf of Ms. Arlisha Henderson. Your Honor, she is not here right now. We have spoken to her. She's
What do you
en
mean,
route.
not right now?
She's just not here right now,
What
Judge.
does that mean?
She had an appointment this morning. She's pregnant, so she did have an appointment that she could not miss. But she says she's en
Oh,
route.
I'm supposed to have some sympathy.
No, I don't, that's not what we expect, Your Honor. I'm just giving. the
That's
court-
not, she doesn't. Really?
If you'd
Well,
like,
no,
it would
you
be
go
nice.
ahead. I will let you make your argument.
It's Judge,
Your client's pregnant, had a medical appointment this morning?
that's correct,
Are you
Your Honor.
sure?
I am, well, that's what she's told us, Judge.
Oh,
Yes. So we did speak to her.
so you
She-
want me to issue a bench warrant?
I absolutely not, Judge. I'd ask that you pass this matter and see if I can get an ETA for her.
Why do I have a feeling this is gonna end up where she's on a bus?
I don't have pictures yet, but I can. And Judge, we do have a resolution in this matter too, but.
Specifically restorative.
I don't know what that is, but fine. I'll pass it.
Thank you so much, Judge.
Court does call the case People versus Dantes Williams.
Alexander on behalf of the people.
Good morning, Your Honor. Hannah Mackey on behalf of Mr. William.
Your name, sir?
Dante Williams.
Thank you.
Your Honor, I believe we would like to set this matter for preliminary examination.
All right. Did you wish to argue the bond? Your bond motion was also
Yes,
put
Mr.
over.
Brown will do that, if that's
Pardon?
okay.
Because I believe at this point his bond stands as revoked. Is that right?
Can I pass this matter, Your Honor, please?
Yes, this was set for
A bond, yes. Bond
the
violation.
bond as well as I think a PCC, so, but I'll pass it.
Thank you.
Court does call the case People versus Marcus Jones.
April.
Good morning, Your Honor. Costa Movesa on behalf of Mr. Marcus Jones. He's in the hallway, Your Honor. Just
I just have to get to speak.
Find out why they got their hand up. I don't have no idea. Oh, they just put it down.
We'll say your full name for the record, please.
Marcus Jones.
Thank you. Take your hands out of your pockets, please. All right.
Sir, today is the date and time set for probable cause conference. At this time, we're going to be requesting for about a month adjournment. My client is to be starting treatment on July 1st, and we would like to show court some progress so that we can get an offer for my client.
Starting what treatment?
He's starting outpatient treatment.
Yeah.
Explain to the judge.
CMA, because I was off my medication for like a few years
Okay, so you're working through CMH.
for treatment,
Pardon?
for treatment to be compliant with my medication.
Okay. Gotcha. Oh, no, we won't have 24. We don't have 24. We only have the 22nd. All right. Probable cause conference will be adjourned to July 22nd, 2025, 9 a.m. That's a Tuesday.
Thank you, Your Honor.
Round will continue. Thank you. I got one. Court does call the case People versus Dominic Kelly Payne.
Good morning, Your Honor.
Kesma Dadush on behalf of Mr. Kelly Payne, stepping in for attorney of record. APD Alexis Plumai.
Okay. Mr. Payne, state your name, please.
Dominic Kelly Payne.
All right.
Your Honor, I believe Mr. Kelly Payne is supposed to be getting a bed at Spera today, which is the reason for Zoom.
Getting,
a bed at Spera.
okay. Is that where you are, sir?
No, not currently. I'll be there at 1 o'clock.
So you're requesting an adjournment?
Yes, Your Honor, we're going to be requesting an adjournment. She filled out a green sheet.
Well, I'll adjourn it to July 3rd, 2025, 9 a.m. so we can keep a status on it.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Nicole Knox.
Andrew Dennis for the people.
Your Honor, Alexis Plumai appearing with and on behalf of Ms. Knox. Ms. Knox, could you state your full name for the record? Your Honor, today is the date and time for a probable cause conference. We have reached an agreement with the people. Ms. Knox is going to be pleading to an OWI second, which is a misdemeanor. I believe the court has that plea form.
I do have a plea form that indicates she's going to be pleading to an added count 2 of operating while intoxicated, second offense, a 1-year offense. Upon her successful guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Yes, that is our understanding as well. And I also have a signed advice of rights and sentencing judge waiver form.
May I have her sworn?
Right hand. You solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name.
Nicole Knox.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense.
Yes,
That's your understanding?
yes,
That is a misdemeanor punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
yes,
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court.
yes,
All right. Understanding all of that, you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes,
Any question regarding any of those rights?
no,
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
probation.
You're on probation. Were you on probation at the time of this offense?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no,
Has anybody threatened you or coerced you?
no,
You're doing this voluntarily
yes,
of your own free will.
yes,
All right, and because you believe that you are indeed guilty,
yes,
I do have to advise you, ma'am, that if you do commit misconduct from the time, if I accept this plea, from the time of this plea up until the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, ma'am?
yes,
You also understand that any sentence, recommendation, or evaluation in this case, the court would no longer be bound by.
yes. I understand.
All right. All right, on date of February 24th, 2024, at the location of Michigan Avenue near Hamilton Street, the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes,
Prior to operating that motor vehicle, you consumed intoxicating liquor.
yes.
What did you have and how much?
I had one margarita.
Pardon?
I had one margarita.
One margarita?
Yes.
All right. Were you stopped by the police or was there an accident?
My. No accident. My car had, my axle had broke.
Your what?
My axle.
The axle on your vehicle broke?
Yes.
Okay.
So I couldn't move. I was stopped by the,
Yeah, usually you can't move without an axle. Did the police arrive?
yes,
Were you ultimately arrested?
yes.
Were you taken to the hospital or were you taken to the police station?
Both.
Was there a blood draw?
Yes.
What were the results of the blood draw?
Your Honor, it was 0.173.
0.173.
Yes, the blood draw.
How big was this margarita?
It wasn't that big.
It wasn't that big?
Mm.
You got to a 173 with one margarita.
I think I had drank it the day before or so.
Do you have any reason to dispute those blood test results?
No,
Had you previously been convicted of operating while intoxicated on or about August 13, 2014 in the Third Circuit Court and of operating while intoxicated on or about July 6, 2025 in the Third Circuit Court?
yes,
Counsel, are you aware of any other threats, promises, or inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court ruling? Would it be proper to accept this defendant's plea guilty to this charge?
Yes, people are satisfied. Thank you.
Yes, Your Honor, the defense is also satisfied.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and screening and assessment is ordered. Sentencing in this matter will be
July 23rd, 5 at 10 a.m.
July 23rd, 2025, 10 a.m. before Judge Barr. Are you on a tether or sober link?
Soberlink. And Your Honor, just to clarify, I apologize that I don't know this. Do you refer to CCOP or Von Schwartz for screening pre-sentencing?
Well, this isn't mine, so you're going to have to ask
Judge Barr.
Judge Barr's court who they go through.
Okay.
Bond with its conditions will continue.
Thank you.
That's like a festival site. It was one? Oh, that ain't right. That's a big old margarita. Yeah, please. If we could order one for the room. Court calls the case, People versus Quincy Jones, both cases.
Andrew Dance for the people. We're ready in this matter.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Jones, who appears to my right.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, also on behalf of Mr. Quincy Jones, and 21F1057.
Yes.
Your name?
Quincy Jones.
Counsel approach. Okay, in these matters, the record should reflect we've had a bench conference in this case. And I informed council that yesterday I'd issued a warrant for Mr. Jones because he hadn't shown up and hadn't been testing. We had already been through this with Mr. Jones before. I released him. He assured me that he would do it. I reinstated his previous conditions. That was on June 5th, and we've not seen him test since. So what I will do, and we had talked about adjourning this matter out, council's checking into some other options, I guess, maybe for Mr. Jones. I'll adjourn this out to June 26, 2025, 9 a.m. You might want to eat your Wheaties that day. It's going to be a long one. June 26, 2025, 9 a.m. Defendant's bond at this time is revoked.
Thank you so much, Your Honor.
All right, defendant's remanded. Court does call the case People versus Sheldon Lewis. Those are recalls.
Sheldon? And our Assistant Public Defender Counsel will base on behalf of Mr. Lewis.
Andrew Van for the people.
Your Honor, I just did receive a message saying that he's on his way, that he's on the bus. He's been.
No, you didn't.
I got it here.
No.
I got it right here.
No.
I've got it right here.
You had the nerve to come up and tell me on a bus.
May I approach, Your Honor?
No. Is that really what you're telling me?
That's
or did
really,
you talk?
That's really what I'm telling you.
Where's what's your name?
I wouldn't make
no.
this up. I wouldn't make
Wouldn't
this
make it up?
I would not. Not in front of you.
Another judge you might. Okay, I get you. Where's a bus from where?
Your Honor, I know he's in Ypsilanti. He's on his way here. I just received another.
Did Mackie tell you to say that? You don't know where he's come?
I know he'll be here soon, Your Honor. If we could just briefly pass the matter.
You know he'll be here soon?
Yes, I do.
You have no idea if
I received assurance from his daughter that he's on his way here just a moment ago.
From where?
From Ypsilanti. She said he left about an hour ago. So I assume he'd be here very soon.
Just take a bus that long? I don't know. Ask Mackie. Mackie, does it take a bus that long?
Yeah.
It does?
I took a bus.
No, you didn't. No, I don't know. I don't even know why you're saying that.
I don't normally ask this of you, Your Honor.
No, you would. You absolutely would. I'll pass it.
Thank you, Your Honor.
If he doesn't show up, I'm putting you on a bus.
Fair enough.
Been a day. Court calls the case People versus Derek Martin.
Stephanie. Stephanie Cannon on behalf of Martin.
Really?
Oh, I didn't even look, Your Honor.
Oh.
Your Honor, my client is expressing this sincere.
Do they not make them as they go under the ground?
From here on out, but the shoes are nice.
What?
Your Honor, we're just
You
requesting.
like the shoes?
I like
Hey, Cannon.
Oh,
No, I don't want to hear about it.
We are requesting a 2-week adjournment. My client is of the understanding and knowledge that from here on out, he will dress in appropriate court attire.
Without a doubt.
Probable cause conference, July 3rd, 2025, 9 a.m. Bond continued. Court calls case People versus Kevin McCullough.
Take the county to the people, Your Honor.
We're ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. McCullough. Your Honor, we received a communication from Mr. McCullough this morning.
He's on a bus coming down.
Not in a bus, Your Honor. He is at the Trinity Health the hospital. He does not have a release date. I was able to share the information sent with the prosecutor, Mr. Kennedy. We're asking for a 2-week adjournment in this case.
That, Your Honor, it may explain why he didn't appear at community corrections, given that I believe he's checked in.
How long's he been there?
6:15. I believe is what you showed me.
Yeah, 6:15 is the date.
Well, if he's been there since 6:15, he didn't report to community corrections as previously ordered, and that was before that date. So that wasn't the reason for his failure to go over to community corrections.
Well, maybe he was feeling ill before that. Your Honor. You know, us men, we like to procrastinate and going to the hospital.
Okay, so here's what I've done. I'll adjourn it out. But he already has a bench warrant out because of his failure to appear. So I'm going to leave the bench warrant outstanding. I'll adjourn this. I have the thing for Trinity Health now, but I'll adjourn the probable cause to July 3rd, 2025, 9 a.m. So they'll have to do that, and then maybe I'll lift it.
Thank you, Your Honor.
Thank you, Your Honor.
What is she handing you? This is Mr. Brown on this case. She's handing you another green sheet on what? Something she didn't do before? Like all the way it's already gone, she's just handing it in now? Why? That's an old green. It's like that case was like hours ago, Mackie. That's all you got. Court calls the case, People versus Joseph Trim.
Said on behalf of people. Hannah Mackey on behalf of Mr. Trim. Oh, he's in the hallway. I'll go get him.
Good morning, Your Honor. Edward Dukes on behalf of Mr. Trim, who is approaching.
Your name?
Joseph Trim.
Thank you. Really? What?
Your Honor, if we could ask this for a moment, I didn't know I knew he was out of custody, but there's an argument regarding bond that I want to go over with him prior to discussing. I'd be asking for an adjournment, but I do know there's a bond argument as well.
He's out. You want? Okay, fine. I'll pass it.
Okay, thank you, Your Honor.
Court calls the case of People versus Mikesha Melkor.
Andrew Damage.
Lori Yagi, Assistant Public Defender, written on behalf of Mr. Melchor. Am I saying that right? Ms. Melchor? Yeah. Ms. Melchor, who's standing to my right. Your Honor, I do have a green sheet. I'm very hopeful that we're very close to a resolution. Ms. Melchor, I'm expecting documentation by the end of the day of her intensive outpatient treatment program. So I am asking for a brief.
July 3rd, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Lanish Mitchell.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Mitchell.
Is that how we have it set?
Yes.
Okay.
What's that?
All right, what are we doing?
Your Honor, upon speaking with Ms. Mitchell, I think it would be necessary for us to adjourn the probable cause conference. We need to do some further investigation based on the information we've received.
All right,
Asking for an adjournment.
I'll need a green sheet. Any objection? July 3rd, 2025, 9 a.m. Bond continued.
And we do want to address one aspect of bond. What's the date? June 19th?
Mhm.
And where do you have to be?
Right there. And I'll leave.
Gunnar, my client has a dance team. She is a verified dance mom. They
She's what?
dancing,
Dance mom, dance coach.
a dance coach and a dance mom. So her team is going to be, I guess, competing in Minnesota on June 19th. And she'd like permission to be able to travel with her team so that they can, do their thing.
You'll see us on YouTube.
I'm sorry?
You'll see us on YouTube.
You can see us, you guys on YouTube? Yeah, me too. So. Are they any good?
Best.
Yeah, we're the best thing.
Why are you saying, have you seen that?
What?
Have you seen that?
It's my client. I did all the way. They're gonna win.
Yeah.
So when does she want to go to Minnesota?
Well, the event is on the 19th, so
Pardon?
tomorrow morning. We're gonna drive.
Till when?
After the performance is over, and we'll head back.
That doesn't tell me. I need a day. Is it gonna be that same day?
21st. It's a 10-hour drive, so it's 10 hours.
Why is everybody explaining all this to me? I understand how far Minnesota is.
Okay, well.
I just need to know, when do
21st
you want to
after, like,
go?
Tomorrow morning, yes,
Till
the 21st.
And the good news, Your Honor, is she won't be taking the bus.
That was crazy.
It's on this
Would
one.
have made it soon.
All right, defendant may travel to Minnesota the 18th through the 21st inclusive for dancing.
You know, we teach
Is it a
everybody.
competition?
It's a performance for the Juneteenth parade, so.
Oh, well, you should have led with that. I mean, fine.
I was
no.
letting him talk.
Oh, you shouldn't do that. All right, yeah, absolutely, you can go now.
Thank you.
All right.
All right, thank you, Your Honor.
Good luck to you.
Thank you.
Troy. Court does call the case versus Keith Moore.
Andrew Banners for the people.
And Alex Warren Green on behalf of Mr. Moore. Gunnar, does the court see Mr. Moore on Zoom? I'm not sure. Okay, Your Honor, I talked to Mr. Moore's.
On the bus with the other guy. Is that what you're gonna tell me?
No, I talked to his community mental health caseworker. She says that Mr. Moore is having some mental health issues right now. I understand CMH has the court's Zoom link, so I wasn't sure if they were going to log in. Your Honor, I'd ask for either an adjournment so that I can, so we can get him to a better place and I can evaluate his competency, or ask the court to pass this matter so he can appear on Zoom. Thank you, Your Honor.
I haven't said anything. I'll pass it.
Thank you, Judge. I appreciate that. I will get in touch with his caseworker right now.
Go on.
Thank you, Your Honor.
It's not going. Court calls the case People versus Megan Moses.
Hannah Mackey on behalf of Ms. Moses, who is appearing via Zoom.
Andrew Banners for the people.
Oh, sorry. Ms. Moses, please state your name.
Hi, Megan Moses. Sorry, I've got a puppy in the background. Please.
Did you?
That's her.
Okay. Your Honor, we're respectfully requesting to adjourn this matter to give Ms. Moses more time to pay restitution off.
The rest, so how much more time is she gonna need to pay it off?
We're still in discussion about how much the restitution actually is.
So we don't even know how much she's supposed to pay?
We do not.
Well, from what
So
I've
when are we
heard,
gonna get that? When are we gonna get that information?
I think there was supposed to be a restitution hearing first before we move forward because there was some issues with what the amount was.
The amount was conveyed, but there was a dispute from the defense with the defendant about it. So I would.
And so how's she gonna pay if you guys aren't I mean, what are you guys trying to do? Besides irritate me?
Your Honor, we were given a number at her second hearing, I believe, and then the number increased by a couple $100 somehow at the third hearing. So
I feel like there's more to it than that. What I've heard and what I talked to with a public defender yesterday was she was also adding her therapy costs and her lost wages for going to therapy. So the restitution I was gonna start a payment plan and then the restitution just kept going up and up. So the payment plan wasn't gonna work. And it's just above and beyond what I can even afford without having a steady income or a vehicle or a car, or I'm sorry, or even a steady home at the moment. So that's why we were gonna have the hearing. So it could go back to just the fines and costs and.
What hearing are we having?
Your Honor,
Other than this one, which is going nowhere?
can we adjourn this matter so we can, Ms. Moses?
Yeah.
Can we adjourn this matter so we can discuss with the prosecution what to do moving forward?
Yeah. All right.
July 3rd, 2025, 9 AM. We can't do anything. You need to set this for a restitution, or not a restitution here, for exam, because I mean, if there's not gonna be an agreement on a number for her to pay and then get a deal, we're wasting time.
Thank you, Your Honor. And may I request to address bond, please?
To what?
A bond modification. May I request to address?
Oh, now you want a bond modification. Go ahead.
Your Honor, Ms. Moses was placed on a tether in April, I believe, for a failure to appear to a court hearing when she did not have access to the internet. She has complied with all of her court orders since then. She has shown up to all of her hearings since then. So we asked this court if she could remove the GPS tether. Ms. Moses rides a bike to work, and it gets in the way of that as well. It just chafes her leg.
Any response from people?
Yeah, I'll leave that to your discretion. My main concern is that the any or all no contact orders remain.
I'm gonna deny the modification at this time, and we can address it on the 3rd, potentially, and that we figure out what we're doing.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case, People versus Nicole Nelson.
Good morning, Your Honor. Student Attorney Andra Sabri on behalf of Mr. Nicola Nelson.
Oh, Andrew Vanderson, excuse me.
Your Honor, Mr. Nelson is not present. I have made multiple attempts to contact him, but I do not have an explanation regarding his absence, unfortunately.
Bench warrant will issue for defendant failure to appear. Bond in each of these cases will be set in the amount of $10,000 cash surety. Warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Antoine Patterson.
Jacob Kennedy for the people, Your Honor.
Assistant Public Defender Sandra White on behalf of Antoine Patterson, please state your name.
Antoine Patterson Senior. Thank you.
Yeah, and I've been talking with the prosecution, and I believe Mr. Bellinger has been handling this matter, and we're asking for an adjournment. They're still waiting on CPS reports.
Do we have any idea when those might be coming?
No, but we'll look into it.
The green sheet, July 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Taiwan felon.
Phelan? Please state your name for the record.
Tawana Taylor.
Thank you.
Your Honor, we are going to be setting this for preliminary exam, please.
All discovery is complete.
Yes, Your Honor.
People would have their witnesses available the first.
Yes, Your Honor.
Preliminary examination will be set in person, July 1st, 2025, 9 a.m. That's before Judge Barr. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Tyler Pittman.
Andrew Van.
Your Honor, Alexis Blumey appearing with and on behalf of Mr. Pittman. Mr. Pittman, could you say your full name?
Tyler Pittman.
Your Honor, we are requesting an adjournment at this time. We did recently provide the people with a mitigation report, so they will need some time to review that, and hopefully we can negotiate an offer. And I do have that green sheet here.
July 3rd, 2025, 9 a.m.
Your Honor, would it be possible to actually go out one more week?
Why?
Mr. Pittman stated he has trouble getting off work and school on 2 weeks' notice, so if we could go 3.
Is that correct, sir? July 10th will give you enough time then?
Yes, sir.
All right, July 10th, 2025. All right, thank you, sir.
Thank you.
Court calls case People versus Jeremy Schultz.
Assistant Public Defender, on behalf of Mr. Schultz, he's in Wayne County Jail. I'm not sure if, I know it was adjourned previously to writ him out, or at least that's what my notes say. That being said, I was going to request an adjournment anyways, because he just said court yesterday in Wayne County, and so he is going to be held in Wayne County until July 7th, which is his next court date, his sentencing in Wayne.
July 7th.
Correct.
I did send the red email, I think it was.
Oh, that makes sense.
Well, if I set it for the 3rd, he doesn't have court on the 3rd.
Correct.
July 3rd, 2025, 9 a.m. That way it'll be enough time for a writ.
Thank you, Your Honor.
Court calls the case People versus Kirby Snyder.
Andrew Van.
Stephanie Han on behalf of Ms. Snyder.
Hello, what's your name? Thank you.
And Your Honor, we're going to ask for I think I put a 3-week adjournment on there. We're going to have her screened for sobriety court, but we're also looking to negotiate with the prosecutor on this matter.
July 10th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Case of the People versus Matthew Vermillion.
And is on behalf of the people, Your Honor.
I'm Melinda Gagne, Assistant Public Defender with and on behalf of Mr. Vermalen, who's standing to my right. Could you state your name for the court?
Matthew Vermillion.
And Your Honor, we are respectfully requesting an exam date in this matter. I do believe discovery is complete.
People have their witnesses available first. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Cynthia Weber.
And Alex Warren Green on behalf of Ms. Weber. State your name, Ms. Weber.
Cynthia Weber.
Your Honor, today's date and time for probable cause conference. I believe we have reached a resolution. I have a plea form from the people right here.
I don't have it. Give it me.
Thank you.
She'd be pleading to operating while intoxicated, second offense.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Cynthia Weber.
All right, ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative program support deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes. Sorry.
And understanding, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Were you on probation at the time of this offense?
Yes.
All right, I do have to advise you that your entry of a plea in this case could be a violation of that probation. You understand that?
Yes.
You understand that if it is considered a violation of that probation, that other court could sentence you to the maximum allowable under the other charge. You understand that?
Yes.
And understanding that, you still wish to plead guilty?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you're indeed guilty of this offense?
Yes.
I would also have to advise you, ma'am, that at the time of this plea, if it is accepted in time of sentencing, if you do commit misconduct, then any sentence recommendation or any agreement or evaluation is basically voided and court is not obligated to follow that. You understand that?
Yes.
You also understand that if you do commit misconduct, you would also not be entitled to withdraw your plea.
Yes.
Hang on. On the date of December 30th, 2024, at the location of Headley near Bartell in Linden Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
3 to 4 beers as well as 4, maybe 5 shots.
Were you stopped by the police or was there an accident?
Tree accident.
You ran into a tree?
Yeah.
Did the police arrive?
Yes.
Were you taken to the hospital?
Yes.
Was there a blood draw?
Yes.
And what were the results of that blood draw?
0.112, Your Honor.
Do you have any reason to dispute those blood test results?
No.
Counsel, have there been any other promises, threats, or other inducements which have led to this plea that were not stated on the record?
None from the defense, Your Honor.
No, Your Honor.
Has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation. Sentencing in this matter will be
August 4th, 2025 at 9 a.m.
August 4th, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Thank you. Thank you, Your Honor. I provided the court with a referral to the sobriety court. This plea is in no way contingent on her screening or acceptance, but I'd ask the court to consider signing that. I talked to probation with the sobriety court, and they advised that they could complete a screening between today's date and the sentencing date.
All right.
Thank you, Your Honor.
Court calls case People versus Taylor Adams.
Advantage for the people.
Your name, sir?
Taylor Adams.
All right.
Your Honor, I retained an attorney, but this is now his second. He didn't show up the first time, and now it's the second time that he hasn't showed up. So I'm asking for a public defender, please.
All right. When you say you retained, did you pay him money?
No, his check is here.
Pardon?
His check is here. That's what I was gonna do the first time. Give him the money when he gets here. He lives his office is out of Grand Rapids.
Oh. The public defender case.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Adams. Your Honor, we're requesting an adjournment. I apologize. I received Mr. Adams' contact information. We just need an adjournment to receive discovery, review it with our client. I'll complete a green sheet for the court. I apologize.
Okay, I'll adjourn this out to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. We'll be in touch.
Okay. Court does call the case People versus Willis Cherry.
Introductions for the people.
David I. Goldstein appearing on behalf of the defendant. State your name, sir.
Willis Cherry.
Your Honor, I'm prepared to ask for a preliminary examination, but I did inquire of Ms. Douglas whether there are any, I do have the written discovery. I don't know if there's any videos. If there aren't, we're ready to go to an exam.
How soon can you get to defense counsel?
I'm showing this as having been discovered, so let me.
Yeah, that would have been to public defender's office.
So I guess it went to the public defender. I can get that done.
Probable cause conference. Are you available the 3rd?
I'm sorry, Your Honor.
Are you available the 3rd?
Yes.
July 3rd, 2025, 9 a.m. Bond continues.
Your Honor, with regard to the issue of the bond, and I'm sorry I didn't get a chance to talk to Ms. Douglas about that. Mr. Cherry is employed, and a lot of his employment is in Lucas County, Ohio, the Toledo area. He is on probation to a district court. They have already given him permission to travel to Ohio, but that's conditional upon you granting that permission also.
Any response from the people? What district court granted him?
15th, Your Honor.
Or is okay with it, I won't
Really? Okay. I'll indicate that defendant may travel to Ohio for work purposes.
Thank you, Your Honor.
Thank you, Your Honor.
My last. Oh. Court does call the case People versus Antoine Pitts. Just that one again.
Ms. Douglas, called Pitts, Antoine Pitts.
Jennifer Douglas for the people.
David I. Goldstein appearing on behalf of the defendant.
He's not here.
Your Honor, Mr. Pitts is having some health issues. He has been recently diagnosed with lupus. He has a probation violation in front of Judge Hammoud. The public defender has been presenting to Judge Hammoud notices from the doctor regarding he's been ordered to bed rest and oxygen therapy. I was hoping to have him, I have several of them on my phone. I was hoping for a more recent one. The most recent one I have is from May. But they've indicated he has lupus and has issues with breathing.
Yeah, but we keep letting him out. He doesn't appear. The last time that you were here, I think I told you I was leaving the bench warrant out. I was waiting on medical. I never got any medical to indicate anything.
Okay, I can get those to
And
the
I
court.
left the bench warrant out. And now he goes through the arraignment process, gets released again, supposed to get to community corrections, doesn't go.
Your Honor, I'm assuming he's not going because of his medical problem.
I don't know that.
Okay, I'll get that stuff to you, Judge. I've got some of
I already issued this bench warrant.
Yes.
He's already got a bench warrant outstanding at this point.
Okay, I'll get the medicals to you as soon as I can, Your Honor.
All right. So I'm just gonna leave the bench warrant out. I'll give a new date on it, but July 3rd. And if he shows up, he shows up. But otherwise, in the interim, there's a bench warrant that's outstanding.
And you'll have the medicals before then, Your Honor.
Recalls the case People versus David Witherspoon.
Joe Simon on behalf of Mr. Witherspoon, Your Honor.
What's your name again, David? David Witherspoon?
All right. The issue in this case is I did call over there are no other violations, correct?
That is correct. One you missed. Sorry, one late test.
There was a late test yesterday. Why?
It was 7 minutes. Well, I asked my client and he basically told me he was worried he was going to go to jail today and he was just.
Well, he should be.
Yeah, because I told him to be. And, but anyway, he has he missed the time slot and then just no good explanation other than he just missed and then he panicked and tested 7 minutes later. But he also wants to let you know he tested this morning too. And there was no violation.
Anything you want to say regarding this bond violation? Because I don't even understand.
He had a bad day and night where he's going to admit drinking alcohol. So that was June 3rd, segue into the morning hours of June 4. And since then, he's been completely compliant other than that 7 minutes. He also wanted to go over to a scram tether because he's so panicked about missing times, etc. He's maintaining that since he'll admit to drinking on the 3rd, but since he's been completely sober. Also, regarding the case, we've reached a resolution between the parties, but I just checked with Mr. Heaton, who was here today from the 14A court regarding sobriety court screening. And I know what my client needs to do. If we resolve the matter the way that we principally constructed, I want to get my client screened and accepted into the sobriety court in 14A first. And I think that will only help him in his issues. If in the interim, he can be on a scram. And if all of that is acceptable to the court, I'd request July 17, because it's going to require a few things for him to get done before being accepted.
Mr. Allen. I will adjourn the probable cause to July 17th, 2025, 9 a.m. The defendant having admitted to the violation, I'm going to sentence the defendant 7 days into Washtenaw County Jail. So he'll be released and then can do that upon his release. He's to be placed on a scram teller prior to his release.
Thank you. So, Your Honor, my staff will try to make arrangements with the community corrections in my absence to make sure that he gets that before release. But in the court, as the court knows, sometimes we have trouble with that. Is there anything?
But we will prepare an order that needs to be placed on the scram prior to release.
I'm saying for community corrections, the jail always is aware of that, but sometimes community corrections doesn't know to do that. You know what I'm
They're
saying?
supposed to be contacted, I think, by the jail. That's how that's supposed to happen. But
I've had trouble with that before. We'll do all we can. Thank you very much, Your Honor.
if you have an issue, let us know.
Thank you, Your Honor. That was July 17th. Thank you.
Yes. Court calls the case, recalls the case, people versus Alicia Henderson.
Andrew Bannis for the people.
Are we ready on that? Court calls the case, people versus Dantes Williams. Are we ready on that one?
Yes, Your Honor.
Well, they call for him. Court does, well, that one coming out. Court calls case people versus Sheldon Lewis. Is that? This is on the bus.
Yeah.
Sheldon Lewis? Oh. Was he driving the bus? Yeah. Or he wasn't driving it, but.
You're ready on this matter, Your Honor, and here he is.
Here he is what?
He was on the bus and he came.
I know. Did he leave all of his pants on the bus?
Yeah.
We won't have that happen again, will we?
Assistant Public Defender Constable Basie on behalf of Mr. Sheldon Lewis, who was present to my right. Have you saved your full name for the record, please?
Yes, Sheldon Lewis.
Your Honor, we're gonna be requesting an adjournment for some video discovery that our office has not yet received.
July 3rd, 2025, 9 a.m.
July 3rd.
All right. Court does call the case people versus Dantes Williams.
Alexander on behalf of the people, Your Honor.
Ron Brown appearing on behalf of Mr. Williams, Your Honor.
All right, I have before me a plea form in this case that indicates that the defendant is going to be pleading guilty to an added count 4 of aggravated domestic violence to 1 year. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. There was some issue because part of this case had been bound over, but then the case got set back for further testimony regarding an additional charge. I spoke directly with Judge Slay. What she had indicated is that those counts, so after I take this, because those counts exist in circuit court, there would have to be a nollie pros filed with the circuit court to get rid of those cases. I can dismiss them here, at least as a record, but those cases are up. So. All right.
Your Honor.
Yes.
Also, I believe party stipulator agree that he would receive sentencing under section 7694A.
Yes, that is on the plea form.
And that he would agree to no contact with
Or
Ms.
no, not to contest her PPO.
Exactly, Your Honor. Which has already been done.
Having sworn.
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Dantes Williams.
All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of aggravated domestic violence. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Harry in the 15th District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You have signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No question, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes.
Yes.
Yes, sir.
I also have to advise you that if there's any misconduct committed by you between the time of the acceptance of this plea and the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, sir?
Understood.
And you also understand that any sentence recommendation and or evaluation, which may include the 7694A assessment, would also not have to be followed by the court. You understand that?
Yes, sir.
Counsel, is counsel aware of any pleas, promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule and would it be proper to accept this defendant's plea?
Do you need a basis? For the
Pardon? Did I not take a factual?
factual,
You're right. I was so concerned making sure I complied with the new court rule that I haven't. I do have to take a factual basis. It's not in front of me. Thank you, Mr. Brown. On the date of April 2nd, 2024, at the location of 2017 Medford Road in the city of Ann Arbor, Washtenaw County, state of Michigan, what did you do on that date involving a Zaylen Gaynor that makes you think that you're guilty?
We got into altercation and I scratched her.
You what?
I scratched her face.
All right. And who is she to you?
Oh, she was my girlfriend at the time.
All right. You didn't have permission to lay your hands on her in that fashion on that date, did you?
No, sir.
And it was not an accident on your part?
No, sir.
Counsel, have I complied with the court rule now? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
yes, Your Honor.
Court will accept the defendant's plea. You count for counts 1, 2, and 3 are dismissed, although 1 and 2, there needs to be the nollie filed circuit court. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 9th, 2025 at 9 a.m.
Your Honor,
July 9th, 2025, 9 a.m. before Judge Barry.
Your Honor, may I address bond?
You may.
Your Honor, my client tells me he's been in jail about 9 months. Is that accurate?
Maybe. I don't know.
Oh, strike that. Strike that. He has not been out 9 months. Now that he's pled to a misdemeanor and the felony charges have been dismissed, I'm asking the court to consider release custody possibly on a tether so he can get back to work. He would stay at 19963 St. Aubin in Detroit, 48233, and have no contact with the complaining witness.
I don't need a response because I'm not going to release him prior. You can take that up with Judge Perry after after he's seen by probation for a screening assessment.
Yes, Your Honor. So bond continues, but once you're seen by probation, call our office. We can take a motion up in front of you. Here's a reminder of your court date and time.
Thank you.
Thank you. Go with the court office.
Court calls the case People versus Joseph Trim.
Ally Zend on behalf of the people, Your Honor.
Thank you for that pause, Your Honor. Edward Lucas on behalf of Joseph Trim, who is approaching. Joseph Trim. Your Honor, I just was appointed to this case. I'm asking for an adjournment to obtain discovery and like to address his tether bond condition.
Go ahead and address the tether. I'll grant the adjournment.
Your Honor,
July 3rd. 2025. 9 AM. Yes, that's the bond.
Your Honor, as to bond, he has the tether and a no-go to an address on International Drive. It's his parents' residence. The parents are not associated with, I guess, the charges in this case. It's because of the complaining witness lived on the either below or above his parents. And so he has a no-go to there. His parents are relatively dependent on him for medical care for his father who has cancer. It's our understanding that the complaining witness has moved out of town and is no longer living at that residence and since been rented to another individual. I've told this to the prosecutor's office. They may be objecting to have it.
Pardon?
I believe the prosecutor's office is objecting. I don't think they've confirmed that yet, but I'm attesting to the court that that's the case and that she has moved.
That's correct. We have not had confirmation that she's moved yet. If we do get confirmation that she has moved, I would be willing to do a stip in order, but at this time we don't have confirmation that she's out of that residence.
So at this time, what I'll do is I'm going to deny your request for any bond modification or change.
Okay.
Subject to some type of confirmation regarding that.
Okay.
That'll be handled by step. Okay.
Thank you. Thank you.
Bond will continue. Thank you.
Thank you.
Court recalls case of the people versus Keith Moore.
Excuse me, Andrew Bannis for the people.
And Alex Warren Green on behalf of Mr. Moore. Your Honor, I'm not sure if he's on there. If he's not, I have not.
Alex Moore. Or Keith Moore, excuse me. Keith Moore. No response.
And Your Honor, his caseworker has not got back to me. I appreciate the court's accommodation.
Will it this time issue a bench warrant bond 10,000 cash here? That warrant will issue immediately. You also understand, so that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 district court.
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, that you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Were you on probation at the time of this offense?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, no, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
June 24, 2022, at the location of Ann Street on Eastern Michigan's campus. What did you do that makes you think that you're guilty?
It was some copper that was in the bin. It didn't belong to me, Your Honor. It did.
There was copper in a bin and you took the copper out.
That did not belong.
That copper did not belong to you.
Yes, Your Honor.
Was the value of that copper in excess of $200?
Yes, Your Honor.
All right. Sir, I also do have to advise you that if I accept your plea between the time of your plea and the time of your sentencing, that if you commit any type of misconduct, you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
And also that if you were to commit misconduct, there would not be, the court would not be bound by any sentencing agreement or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, is counsel aware of any other promises, threats, or inducements that have caused this plea?
No, Your Honor.
None, Your Honor.
All right. And have I complied with the court rule?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing will be
July 7th, 23rd, 2025.
July
23rd.
July 23rd. Thank you. July 23rd, 2025. What time?
10 a.m.
10 a.m. before Judge Barr.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
You have a nice day.
You too. Court calls the case of the people versus Cody Moore.
Ashley Lonnie for the people.
I really have no main question.
And Alex Warren, Green on behalf of Mr. Moore. Mr. Moore, can you state your name for the court?
Cody Moore.
Your name, sir?
Cody Moore.
Okay, go ahead.
Your Honor, today's date and time for preliminary examination. At this time, the defense is ready to proceed.
And Your Honor, it is my understanding the defendant does have an active bench warrant out of this court, is that correct?
Yes.
And I had understood he was in custody in Jackson County. We are not ready to proceed at this time. We would request an adjournment.
The defense would move to dismiss at this time, Your Honor, and if the court has questions about his current status, I can provide some more information.
Go ahead.
So, Your Honor, he was taken into custody by his parole agent to the Jackson County Jail. His parole agent allowed him to be released so that he could make his court date today. We adjourned last time because we were hoping to resolve this prior to coming back to court. Those negotiations, Mr. Moore did not hold up his part of the deal. We came back to court today, ready to hold a preliminary examination. And at this time, if the people are not ready to proceed, we would move to dismiss. After speaking to the people, I think my client understands that this case could be reauthorized and he could be taken into custody immediately if the people do choose to go that route and if the court, of course, grants our motion.
He's currently on parole.
Yes, sir.
Yes, Your Honor.
People being unable to proceed, this case is dismissed.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Case of the people versus Javon Smith.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Smith, who's here to my right. State your name, Mr. Smith.
Good afternoon, Javon Smith.
Joe.
Andrew shows his hand up. All right, what are we doing?
Your Honor, this is a date and time scheduled for preliminary examination. I have gone over his absolute right to a preliminary examination with Mr. Smith, and he wishes to waive that exam. We've executed the appropriate waiver form.
Is that correct, sir?
Yes, sir.
You do understand that a preliminary examination is meaning the people have to show by probable cause that the offense alleged was, or the offense is alleged and committed.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Sir.
People also waive the right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, in terms of arraignment on the information, we'd waive reading, stand mute, acknowledge receipt of the information.
Defendant having waived formal readings, you court will enter not guilty plea. Pretrial in this matter will be set for
August 7th, 5 at 1:30 with Judge Slay.
August 7, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond.
Every day, Your Honor. Thank you.
Thank you, Judge. Court calls case people versus Larry Lee.
Good afternoon, Your Honor. Mary Tanha, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess. with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes,
Okay, could you please state your name?
literally.
What is that noise?
Shouldn't you check? I don't feel safe. Why are you just pointing? What?
Don't stop. So
It'll stop at some point.
I feel very safe, Your Honor.
Oh, I know. He's like, you are all over it. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge, because we want it documented for potential additional charges. But this all happened, transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
Hold it, but does that recording indicate that?
Yes, Your Honor, have either one of you listened?
I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's your name?
Mary Rubio, Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he
had not heard anything, and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know, are you a lawyer?
I was,
Mr. Lee, no, to my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorney. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you.
Thank you. Court does call the case, People versus Brandon Carter.
Andrew Silver's appearing on behalf of the people, Your Honor.
Stephanie Cannon, appearing on behalf of Mr. Carter, who I do believe is appearing by Zoom, Your Honor.
For an exam?
Your Honor, the prosecutor and I. Yes.
I'm here.
But no.
I'm here. I'm here.
But no, there's a thing, Judge, there's a thing, trust me. So we have decided to, ultimately, we're going to waive it. So we're adjourning for the waiver.
Right here.
Please. Pretty, please.
What do you mean?
So he's going to waive his exams.
Today?
Why?
Yes, if you're going to allow it, Your Honor, we'll waive the exams today if you're going
Why
to allow
isn't
it.
he here?
So,
Because this is a
Mr.
preliminary exam day.
I understand that, Your Honor. Mr. Carter, how to say this? So he had some things to deal with in Wayne. They picked him up. When they released him, they wouldn't bring him back here because remember he came here, he was staying at the Lannis. And so he had to go back to Wayne. And then they were like, we don't want you, basically they tethered him there and wouldn't allow him to come back up here. And we found this out this morning and I spoke to the prosecutor about what was happening and it's my understanding he's okay with adjourning this so we can waive it or we can do the waiver with him on Zoom. Please.
Is he waiving everything up to circuit?
He's waiving everything up to circuit. Everything's gonna go up.
Your name, sir?
Brandon Carter.
All right, you're waiving your right to have a preliminary examination in both of these matters?
I don't want to. I don't know what I'm doing. Well, yes. My
Which
lawyer
is why
knows.
we were adjourning it, Your Honor.
He needs to be here. I mean,
Well, I don't want to do the bus thing.
You know what? It's like the third case of the bus. I just,
He's not on the bus because when he called me this
no, I
morning,
can see that.
okay.
There aren't trees going past the window.
So when we spoke this morning, we discussed what had happened and why he wasn't here and everything that was going on. He was going to get on the bus, but he was like, if I get, it would have been a repeat of the last time because he's in Detroit. And so Your Honor, we're asking, can we have a 1-week adjournment? He'll get up here for it. He'll come the day before,
Yeah.
but it'll just simply be for a waiver.
This is set for PE. A 1-week adjournment puts it in front of another judge.
We're not going to hold the preliminary exam. We're going to waive it. I mean, I understand what you're saying. I do, but I just need to get it to circuit court.
But he says he doesn't want to. Because I can do the waiver with him on Zoom. So if he's gonna waive, he can do it now. If he's not gonna waive, we've got a problem because he's supposed to be here.
I understand that, Your Honor.
Okay, we
And
waive.
we discussed this, Mr. Carter and I discussed it. He discussed it with my office, the reasons for it. I do believe that this would be in my client's best interest, Your Honor.
But he says he doesn't know.
Okay,
So,
I'm gonna waive it.
no, so he needs to get here or he needs to wait. Did you want to go and phone him and talk to him?
Mr. Carter, are you
Because
going to waive?
I'm gonna waive it. I'm gonna waive it.
All right. So you're waiving your right to have a preliminary examination in both of these cases?
Yeah.
Have you had an adequate opportunity to speak with your attorneys regarding that waiver?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive your right on these cases?
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on the one count in the 15th district court matter and on all 4 counts in the 14A2 matter.
Okay.
Your turn.
Thank you, Your Honor. Your Honor, as to both cases, my client would waive the reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for
August 11th, 2025 at 1:30 with Judge Hume.
August 11th, 2025, 1:30, Judge Hamud.
I do have a question. I'm looking over the notes in my file. The last note I have from the 13th of May is that the bond, the defendant was in Rowe County Jail, and the bond here was set at 10,000, 10%. That bond posted.
And I thought he was on
You said 10,000, 10%?
I know,
Is that May 13th?
May 13th.
May 13th, I'm looking at it. I set his bond at 1,000, 10%
Okay. Oh, you know what? You're right, 1,010. But that's,
in both cases.
was that posted?
I don't believe that it was.
I don't think the reason I'm asking Your Honor is the court, on a totally unrelated case, we recently had someone who was just let out of the county jail in Wayne, the bond that hadn't been posted here, and that jail didn't seem to mind letting them out of their jail. So I was concerned that a similar situation happened here.
Well, I don't know if it's been posted.
It has not been received by either 14A1 or 15, if it was posted.
Your Honor, I will talk to my client about making sure that bond is posted, but again, I will work with him on it. Yes, Your Honor.
Thank you. I'm trying.
Well, this may become Judge Hamud's problem at some point. So I'm just gonna continue his bond. He's gotta get it posted. 'Cause
We'll get it posted, Your Honor.
he really should be in.
And again, I'm assuming Wayne did the exact same thing. It's
Wayne County.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Kayla Keys.
And then on behalf of the people, Your Honor.
Your Honor, Alexis Kumai on behalf of Miss Keys. And Miss Keys, could you say your full name once you get up here?
Kayla Alexis Keys.
Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, people are unable to proceed as to count one and ask that count two be remanded to the chief court.
And Your Honor, the defense would move to dismiss count one. And we would also like to very briefly be heard as to bond after we get that pretrial date.
Continue the defendant's not guilty plea as to count two. Count one is dismissed. We'll set a pretrial date in 14B before Judge Washington 4.
July 21st, 2025. 10 a.m.
10 a.m. before Judge Washington. July 21st, 2025. 10 a.m. before Judge Washington. As to bond.
Your Honor, at this time, Ms. Keys is currently on a GPS tracking tether. That was modified at her last probable cause conference, I believe, from a hot zone tether after it was confirmed that the alleged victim had moved out of their apartment. So currently it is just tracking Ms. Keys, not preventing her from going anywhere. Seeing as the case has now been remanded down to district court and Ms. Keys has had no bond violations thus far, and has attended every court date, I would just ask if that tether could be removed and we just do not go to the alleged victim's current address.
Response.
Your Honor, at this time, I would object to modification of bond. This case originally was a strangulation. I have concerns for victim safety. This is still an incident of domestic violence, and I would ask that.
Doing everything. I'm not going to modify the bond to take the tether completely off. Motion for bond modifications denied. Bond. Thank you.
Understood. Thank you.
Court calls the case People versus Clifton Watson.
Ally Zend on behalf of the people, Your Honor.
And Lori Yaki, Assistant Public Defender, with and on behalf of Mr. Watson, who is a pro se. Could you state your name for the court?
Good afternoon, Your Honor. Clifton Levi Watson Jr. Thank you.
And Your Honor, today's date time set for preliminary examination. At this time, people are unable to proceed as to count one and ask that count two be remanded to the court.
And Your Honor, we would move to dismiss count one.
People will be unable to proceed on count one. I'll continue the defendant's not guilty plea as to count two. I will then set a pretrial date before Judge Barr on
July 10, 2025 at 8:30.
July 10, 2025. What time?
8:30.
8:30 before Judge Barr.
Your Honor, may I address bond?
Briefly, yeah.
Okay, Mr. Watson does have a separate address. He is a father and he's been really struggling with his mental health and with his physical health since he's been incarcerated. He does deny the allegations. This is the only case he has in Washtenaw County. He does have a few holds, but so he understands that he would have to go. But I have been in touch with his attorney in Wayne County, who is very optimistic that he wouldn't actually be held in custody on his Wayne County hold. He has been struggling with his mental health and his physical health here. He would be able to comply with the no contact order. He has a separate address, separate residence. He's willing to do a GPS tether. He just wants to be able to take care of his children and himself out of custody.
Your Honor, I'm gonna object to any modification of bond. In this case, he does have a hold on a wing where his bond is denied. He also violated his bond while in custody by calling the victim 7 times and attempting to call her, I believe, 9 times, but not. He already violated his bond while in custody. And given the fact of this case, I would ask that bond remain as set.
Anything else?
Only that I don't have a copy of those phone calls. His phone privileges were revoked at the probable cause conference. Unfortunately, I mean, I can't really speak to it because I don't have the calls.
Motion for bond reduction is denied. Bond will.
Thank you, Your Honor.
All right, court does call the case of the people of the state of Michigan versus Lewis Howard Goodine.
Andrew Childers appearing on behalf of the people, Your Honor.
Good afternoon, Your Honor. For the record, Raymond Burkell on behalf of
Sir, could you please state your name? All right, very good. Date and time set for preliminary examination. Are we ready to proceed?
We're ready to proceed.
Yeah. Your Honor?
Yes, sir.
Other bedroom, which really didn't have much like decor or anything else.
And Sergeant Pitt, are you familiar with the term like proofs of residency?
I am.
Okay, what does that term mean to you?
Means proof that that subject lived in that apartment.
Okay, in your search of the apartment, did you locate any documents, items, or any other things that would suggest proof of residency that would associate this apartment with the defendant, Mr. Goodine?
We did. We located mail. We located his 2 Michigan IDs that were him. I believe that was in the nightstand next to the bed. We also located documents from his landscaping company, Dream Mascus Landscaping. That was located in the master bedroom on the desk where the cocaine was located.
Okay. You've testified to 3 long guns located in the master bedroom. Did you locate firearms anywhere else in this apartment?
I did. Besides the 3 long guns that were all AR-style rifles, we located several pistols in the secondary bedroom. In, I believe, the closet.
In the closet? Okay.
And it was in a cardboard box.
Did you locate any guns in the laundry room?
I don't remember, but I don't believe so.
Okay. And how about the kitchen? Okay. And was there like a living room area?
There was.
Any firearms in that?
I don't believe so.
Okay. So the firearms are basically in the 2 bedrooms.
Correct.
Okay. The other bedroom, not the master bedroom, but the other bedroom, did it appear based on your observations that anyone was staying in that bedroom?
It didn't appear so.
Okay. And Detective Sergeant Pitt, did you locate any large quantities of US currency in the apartment?
We located, I believe, $5,000 in the apartment.
Okay. Do you recall approximately, or do you recall where that was located within the apartment?
I do not, but if I'm allowed to look more quarterly.
Would that refresh your recollection? That's fine. Sergeant Pitt, I noticed you're still flipping through. I don't know if you have your entire report. I printed off a portion of it. Is it not referenced in the report that you have?
I found it.
Okay, great. And where was it located?
So we found $4,500 on the table and the dining room area, which is adjacent to the kitchen and the living room area.
Okay.
$500.
On the counter? Where was the counter of what?
The kitchen.
Okay, thank you. And Sergeant Pitt, in your approximately 4 years with LawNet, can you give us a rough estimate of the number of times you were involved in searches of residences associated with potentially drug trafficking?
Specifically narcotics, well over 100.
Okay, and in your training and experience with LawNet, the quantity of drugs located in this apartment in Pittsfield Township on April the 4th of 2022, is that consistent with personal use or with the intent to distribute?
That's consistent with trafficking.
Okay, and that's based on what? Okay, and specific to the facts of this case, is it the quantity that is most jumping out, or is it how it's packaged, or not all of these factors?
Both, because you have a large quantity of scales.
I didn't ask you about that. Did you locate scales in the apartment?
Yeah, it is scale in the apartment as well.
Okay, thank you.
And then also there's a money counter located in the apartment. With the packaging of it, the quantity and the paraphernalia located, it's consistent with, distribution.
Thank you. I have no further questions, Judge Your Honor.
Cross-examination.
Thank you, Your Honor. Good afternoon, Sergeant Pitt. Just a few questions about things that you just said. The search warrant that you got was based on 4 controlled buys. Is
Your
that
Honor,
correct?
I'm going to object at this point. The purpose of this proceeding is probable cause that a crime occurred which relate to the execution of the search warrant. The subject of the matters of the search warrant would be properly motioned and here before the circuit court, which relate to either possibly a Frank's hearing or that the search warrant lacked improbable cause. But as it relates to the validity of that search warrant, for purposes of this proceeding, I don't believe that that is an issue that should be raised before this court.
Your Honor, you have the absolute right. I don't want to say duty, but to hear the background of how he got this search warrant and what he used to get this search warrant and considering the totality of the case. They just can't come in here and say, I got a.
What are you challenging with reference to the search warrant?
Well, my question was this. You did 4 controlled buys. Yeah. And did it involve this defendant? And I want to discuss the controlled buys that this defendant is accused of having, which he told a magistrate in order to get a search warrant. If he gave the magistrate false information or misleading information, it doesn't need to go to circuit court. I mean, you are a judge, you can make that call yourself.
And Your Honor, the proper, that's what Mr. Burkett is referencing would be a Frank's hearing under Franks v. Delaware. You're only entitled to going into the contents of the probable cause of the search warrant if there's sufficient showing by defense attorney that there's either a deliberate falsehood or a reckless disregard for the truth. And it has to be more than just an accusation. There has to be an affidavit or support that the police either deliberately false or reckless disregard for the truth. Otherwise, you risk unfairly disclosing the identity of a confidential informant as it relates to these buys. We don't get to just have an interrogation of this information absent some showing by the defense attorney that it would be warranted.
Your Honor, the prosecutor is so wrong about this. He wants you to believe that you can just show up and say, I had bias from a person, but we need to go to the circuit court to determine whether the information I gave that magistrate was correct. If he presented a bunch of falsehoods to a magistrate.
Okay, and Mr. Burkett, while I might agree with you, I guess my concern is I've asked you what specifically a proffer of what you're trying to elicit.
Well, elicit several things. First of all, it's going to be our contention that he operated on false information. Well, see, here's what our theory of the case.
But who operated?
The officer, correct, and he gave that false information to the judge. But let me explain to you our theory.
Stop. That who gave false information?
Your witness on the witness stand. And it's false information from a confidential informant.
False information from a confidential informant. So
to get a search warrant, the information was not true. The information was hidden from the magistrate. If they would have told the magistrate that
what information are you saying is hidden? I mean,
first of all, that my client possessed any of this narcotics. That's the first thing. And that he sold any narcotics to anybody. We're challenging that. And we can challenge that at this level. But the rule for the prosecutor to come and say, well, that's not important. take that to circuit court.
Well, I don't think that's what they're saying at all. I mean, but I still don't know. To the extent you're indicating that I could make this inquiry into certain aspects of the search warrant. What are you telling me that was so false as to not?
I tell you what, hold that thought for a minute. Let me go to something else that will lead you right to this. And let me go to another.
Okay, well, I'm not gonna hold the thought, or you can go to something else because you're not giving me any answers.
Okay.
I don't know what I'm holding.
I want to talk about the search warrant in and of itself, okay?
Are you going on to something else?
Yes.
Okay.
Yes.
All right, go ahead.
But that doesn't mean I'm not coming back to this, but okay. Officer Pitts, I wanted to discuss with you the search warrant that you got from the magistrate, okay? Now, you just told this honorable court that you got proof of residency of my client, correct? You were required in the search warrant to file a return where you listed the proof of residency you got. What does the return on the search warrant allege that you took?
I don't have the.
Beg your pardon?
I don't have the,
Prosecutor will give it to you.
I didn't print it up.
Okay, you just told the honorable court that, I'm sorry, before we get to that, Yana, would you allow me to approach the witness with a copy of the return on search? Sir?
Yes. Is the prosecutor saying?
I didn't see it.
I don't know if the prosecutor thinks, but I wouldn't, okay.
What?
I don't know if he's seen that, but this is the search warrant that they gave us.
Well,
just need to make sure.
But if you pull two pieces of paper out, I don't know that. And I'm just saying, show it to him and then we can go.
Sure. Yes, I agree.
I don't see the proof of residency on the return.
Beg your pardon?
I don't see the proof of residency.
You didn't see it because you didn't file it, correct?
Correct, we didn't seize it now.
Okay. Now, the court ordered you to find certain things and to seize them, correct? In the search warrant, or do I need to show you a copy of the search warrant?
We photographed it. That should be.
I didn't ask you that. My question to you was this, straight up. The court ordered you to find certain things and to seize those things, yes or no?
I believe so.
Okay. Now, one of the things the court, first of all, you agree then that the proof of residency is not on the return of the search warrant, correct?
Correct.
And no, it's a yes or no answer. The court ordered you to find and seize proof of residency. You didn't do that.
I'm gonna object. This is a misstatement of law. The search warrant allowed the police to enter the residence and look for items. They documented those items and seized certain items. The idea that they ordered him to seize certain things, I think is a misstatement of what's going on.
Oh, first of all, I haven't seen what the particularities of the search warrant are. So I don't know what was asked to be documented, searched. I have no idea.
If you recall, in the search warrant, do you recall the court asking you to find materials that might be used to dilute controlled substances?
I don't recall if I can do it.
Please do.
I don't think I have a search warrant in front of me.
Beg your pardon?
I don't think I have a search warrant in front of me.
Let's see.
I don't have the search warrant in front of me, sir.
Is that the search warrant that was being handed to?
Okay, I see what you're referring to.
Beg your pardon?
I see what you're referring to.
Yes, okay. Now, did you see any weight scales? Yes or no?
No.
Did you seize any records showing that any narcotic transactions have been said? Did you seize any records?
We see the cell phones, but I don't think there's any records of.
Okay, the answer is no, you didn't. Well, let me ask you this then. Did you seize any material that shows the sale of any cocaine?
No.
When I say seize, I'm going to also ask you, did you put this thing on your return? Did you seize anything that shows he stayed in that place?
No.
No. Okay. There was a computer there. Drug dealers, a lot of times, their sales and things on the computer. Did you seize his computer?
No.
No. What you seized was $4,500 in cash.
5,000.
Beg your pardon?
5,000, sir.
Well, okay.
And I don't believe we seized his laptop. I'd have to look at the return just to verify, but I don't believe we seized it.
Okay.
So I'm maybe just doing that on that.
Okay. Now, when you went into the place, of the apartment, Sarah, how did you get in?
I believe we used the key to access the front door.
Where did you get a key from?
Management office.
Okay, and you showed them the search warrant or what?
One of the other detectives handled that, so I'm not sure if he showed the search warrant or not.
Okay, and when you went into the office, did you or any of your members ask for any rental agreement to show he was staying in that apartment?
I'm not sure.
Well, did you see any rental agreement?
No.
As you sit here today, you cannot tell this court that Mr. Godown lived in that apartment, can you, sir? From personal knowledge.
I believe he did.
No, I didn't ask you to say, I said, can you tell us that he did or did not? Do you know personal knowledge?
Yeah, he looked.
Tell me how you know that, sir.
We located his 2 driver's license in the nightstand in the master bedroom, photographed that.
Okay, did you see his license and photograph?
Your Honor, asked and answered.
Just saying.
Okay. Is there any particular reason why you didn't seize his license?
Well, it gets to a point where our facility is only so big, so I mean, the evidence that he lived there would be DNA on his pillow, we're not gonna see his pillow. So we have to kind of pick and choose what we're going to
Okay.
take.
So I can't show those license to this judge that you claim you saw that, correct?
There's photographs of it, sir.
Thank you. Now, was anyone else living in that apartment with him? If you know from personal knowledge.
I do not know. Personally, I do not believe so.
Okay. When you did not seize or take pictures of any clothes that were found in that apartment? Yes or no?
There should be photos of the closet, which would contain some clothing. If I see clothing, no.
Did you take photos of the clothes?
There's photos of the closet, clothes in there.
Okay. The clothes that you took pictures of, sir, I'm sure you have a good memory. Were there any women's clothes?
I do not remember, sir.
Beg your pardon?
I do not remember, sir.
Okay. Was there a woman, based on your knowledge, living in that apartment?
I do not believe so.
No, do you know?
I don't know.
Okay. Did you ever have the apartment under surveillance?
We did.
Okay. And did you ever have anybody go into that apartment?
Any of our undercovers?
Or anybody?
We had a confidential informant.
Okay, he went into the apartment.
the report, but I believe so.
Okay, well, it is in your report, though, isn't it? Now, how did he get into the apartment?
Your Honor, I'm gonna check at this point where Mr. Burkett is trying to do an end around to get into the identity of the confidential informant without a proper showing under Frank C. Delaware.
Well, no, that's not what Mr. Burkett is trying to show. What I'm trying to show, yeah, basically is this. They claim he was the only person, I think that's what they claim, in the apartment. We're showing that there were other people who lived in that apartment.
How are you showing that?
I'm asking him, he sent somebody into the apartment. Based on what they found, was he the only person living there? That's crucial to our case, because we're claiming the drugs are not his, they belong to somebody else. How can I get to that if the prosecutor's trying to hide all that?
I'm gonna sustain their objection. I think I've let you go much further than I really necessarily should have, because I'm still not sure what direction you're trying to go, Mr. Burkett.
Okay. Yeah, I'm sorry. Were you finished?
I'm done.
Your Honor, our whole theory is there were other people living in that apartment. And what I'm trying to show is he knows there were other people living in that apartment. But let me ask you this way. When your CI went into the apartment, did you ever receive any information that there were other people living in that apartment?
Same objection.
Sustained.
Yeah. So it wasn't important to you then whether or not there was other people living in that apartment. Is that what you're saying?
No.
It wasn't important? Well,
How we keep asking questions that are assuming facts not in evidence, first of all. Because you say there are other people, keep repeating that there are other people, doesn't mean that there are other people.
Based on his investigation, did he say that there were other people living in the
Okay, but
apartment?
Mr. Burkett, even if let's assume for the sake of argument that there are. Okay. I don't know where that gets you for the purposes of preliminary examination, because if your client's there and there could be a notion of joint possession, we're still in the same spot.
You're right, but they haven't.
I know.
I didn't mean it that way, you know that. But they haven't shown my client to be there. That's my whole thing. They have not shown him to be there at all. At no point did they show him to be there. So
But then you asked that question about 15, 20 minutes ago.
okay. You never saw my client in that apartment, did you?
Inside of the apartment?
Yes.
After
Afterwards. I mean, before this, did you ever see him?
before, did I personally see him inside the apartment?
Yes.
I did not.
You had no information. Okay, they're gonna check it out. You also, sir, went to his bank, and you executed a search warrant on his bank, correct?
Correct.
And what was the purpose of that?
To locate any sort of funds, see if you could locate anything that would be relevant to a narcotics investigation.
Okay, and could you tell Judge Simpson what you found based on your search warrant in the bank that would incriminate my client?
Nothing that would incriminate him.
Nothing. How many banks did you go to?
One or two, I believe, I'm not sure. I don't
Would you
remember.
disagree with me if I said you went to 4?
I'm not sure.
Okay, so you wouldn't disagree with me. But anyway, be that as it may, all the banks you went to, you found absolutely nothing, correct? Okay. I want to ask you about the guns that you found in the house. Were the guns you found all legal guns?
I believe so.
Okay. Did you find out who owns the guns?
I believe so, but I can't remember.
You don't-
That's 3 years ago.
And, okay, but as you sit here, you have your report, you read your report because you testifying, so you can't tell this court that who owned those guns.
I believe Mr. Goodine did, but I'd have to.
That would be
my
it.
report in order to see for certain.
When you went to ask for a warrant, you didn't ask for a warrant for Mr. Goodine, did you, for a felon in possession of firearms? Why not?
I'm gonna object to the relevance of this question. I don't know what it has to do with. He's not
Forget
charged
it,
with felony
forget it,
possession.
forget it. I withdraw.
Sustain the objection, but you know you shouldn't have asked it.
You don't have no more coffee over there, do you? Guess I can show you, okay.
The Starbucks down the road. If you want to go now, go for it.
He's a resident of the apartment.
Where's this picture from?
It's from me to you, to show you that that was a resident of the apartment living there.
It's just Your Honor, I've been handing a picture of some random individual with a beard and a blue sweater. I've never seen this person before in my life. This was not tendered in discovery, Mr. Burkett, to you? Was this tendered in discovery to you?
It was.
By me?
I don't know who was who in your office.
I don't know what this is, Your Honor.
Where did it come from?
From the prosecutor's office, I would imagine, but like.
So what do you mean you imagine? Was it in discovery or not?
You know, I'm sure, but let me, Judge, here's my.
No. And quit the diversion.
I can't answer that.
Why can't you?
Because I don't know the answer to that. I don't do the discovery much. I don't go through it. I got a staff that does that. All I want to know.
Oh, really? Okay.
All I want to know.
That's your defense for not knowing?
I can assume like the officer.
Because no, Mr. Burkett. You were about to give a document. I don't know if you're going to try to enter it into evidence, but you were certainly going to have this witness testify as to a photo. You show it to the prosecutor. Prosecutor is wondering where that photo comes from. And right as I ask you, which I think is a legitimate inquiry, you can't tell me where that photo came from.
No, sir, I cannot.
Then it's not going to that witness.
Okay, my only thing, I understand your ruling.
Okay, then why are you still talking?
I thought that's what lawyers do. We talk.
I know, sometimes way too much. So young lady, you may sit down because that's not going up there.
Okay, Your Honor, the only purpose of showing the witness that photo was ask him, is this one of the residents in?
Okay, look, I don't care what you were gonna ask. I'm done. If you can't tell me where it came from and the prosecutor doesn't know where it come from, I'm done talking about it.
I understand, Judge, I understand. I'm only doing that for appellate purposes. That's the only reason. All right, but let me.
To appeal a photo, you don't know where it came from and the judge won't let you ask questions about it. Okay, good luck. Go on, next question.
Judge, I'm just about finished.
Oh, we can only hope.
Beg your pardon?
Nothing. Go ahead.
Just so the record is clear, I'm not allowed to ask any question concerning the buys that were made, the 4 buys that were made to my client. Is that correct, sir? You objecting to the 4 buys that were made? Yes or no?
I'm making the same record that I made before.
Okay.
Getting into the substance of the search warrant is improper, absent a showing under Frakes v. Delaware that there is reckless disregard for the truth. I'll read it. So
go on.
the defendant is entitled to an evidentiary hearing in order to show that the affidavit is void when the defendant makes a substantial preliminary showing of a deliberate falsehood or reckless disregard for the truth by the affiant. Absent that, my position is that we are not to go into the contents of the affidavit that led to the search warrant.
I have no further.
Any redirect?
I have one question. Sergeant Pitt, in regarding proofs of residency, did you find any proofs of residency in that apartment with any person's name on it other than the defendant?
I don't believe so.
No further questions.
You may step down. Thank you, sir.
No further witnesses, people would rest, Your Honor.
Any witnesses for the defense?
None.
Now, at this time, people would move to bind the defendant over as charged on the 2 counts before the court.
Judge, I don't think there's been any showing about those guns that were there, about my client had, about felony firearms statute. I'm asking you, I don't know whose guns they were. They have no proof of relevancy, but under the law, I think you have to dismiss them.
You're saying this account two?
Yes.
All right, anything else?
No, that's it.
All right, the court, having heard all of the testimony in the case, the court does believe that the people have indeed sustained their burden of showing, certainly as to count one, that there was cocaine as testified by Sergeant Pitt, that there was cocaine in the Bridle Run apartment in an amount in excess of 1,000 grams. Certainly for purposes of preliminary examination, that portion of that charge has been shown and that it was packaged in such a fashion that it wasn't for someone's personal use, but some type of, as a witness testified, manufacture and delivery. That as to the possession of that, the testimony is also clear that the only person associated with that apartment, the IDs and other information that were obtained via the search warrant, all indicated that Mr. Brown was the only individual in those premises. So court believes for the purposes of probable cause that the people have shown the actual narcotic that was present, that being the cocaine, but also that the defendant possessed that cocaine with the intent to deliver. As to count two, the felony firearm, I think defense may be mistaken as to whether or not the guns were legally owned or there was some regard to the propriety of those guns. What's clear is that there were firearms present. Sergeant Pitt was very clear about the location of those particular weapons, being in the master bedroom, or at least the occupied bedroom, and then the what could be called the unoccupied bedroom. If there were pistols located there, there was also ammunition and other things that, although those being long guns, maybe under other circumstances, they would have been certainly legal to possess without any interference. When one is in the commission or in the throes of committing a felony, that being the possession, and certainly the possession with the intent to deliver cocaine, the possession of those firearms in and of themselves become a crime. And so for those reasons, the court believes also that the people have sustained their burden of showing that the defendant was in possession of firearms during the commission of an ongoing felony. So for those reasons, the court would find that the people have sustained their burden and would bind the defendant over on both counts 1 and 2 to stand trial. Do the arraignment.
Stand. I was trying to stand up.
No, that's fine.
Stand mute. We'll wait.
Further reading. Defendant having waived reading, court will enter a not guilty, and standing mute, court will enter a not guilty plea as to both of those counts. Pre-trial in this matter will be set for
August 13th, 2025 at 1:30 with
before Judge Conlon.
August 13th?
Yes, sir.
Thank you.
Any issues regarding bond?
What is the bond set up?
Yeah, you don't want me to tell you. Hey. The bond is set at $2,000 cash as surety, which is an amazing thing as far as I'm concerned for an offense that carries
I have the defendant's
life effect.
I have the defendant's guidelines scored at a minimum of 108 months with a maximum of 100 months. Shockingly, the defendant does have no criminal history, but we have an individual with $20,000 plus worth of cocaine, multiple firearms positioned throughout the apartment, a very significant quantity of drugs with a mandatory, as well as the 2 years on the felony firearm. You know, this is a case where the defendant is facing what I would call inevitable time in the Michigan Department of Corrections. And he's on a $2,000 bond on a life offense. I believe that bond is improper and would ask for a 50,000 surety bond.
I will certainly object to that. And the prosecutor is asking for that bond simply because we held this exam. Number one. Number two, which is more important, Mr. Childress and I argued the same motion before your brother magistrate here. And the magistrate
My brother magistrate.
another magistrate, I'm sorry.
I didn't argue.
Well, I am not, I don't know what other magistrate there is. I am not a magistrate.
I'm not a magistrate.
Yeah, I'm a full-blown judge.
Judge, I'm tired and I'm in pain, so I made a mistake, but you know.
No, it's okay.
You know I don't disrespect you.
No, I know you're not.
I can respect all the disrespect, but anyway, one of the things that the court ruled in that, when Mr. Childress made this argument, was simply this, that this happened in 2022. The government waited over 2.5 years before they even sought a bond. So they can't come in here and say he was a danger to society or he was a menace to society. And then ordered that low bond for that reason, because they waited so long to get a warrant. And now that he got a warrant and he has a tenant, he's done every single thing that this court has asked him to do. We even have to leave court today so he could go next door, because he got a buzz while he was here to go next door. To you to issue a higher bond on that, based on the conduct that he has shown, it to me is just punitive. He hasn't violated anything. He owns his own business. He has contracts with those businesses. If you lock him up, he'll lose all those things, Your Honor. And there's no basis to lock him up. Not when he's come to court. He's not missed any
I
appointment.
have an individual facing a life offense, and now I've heard the testimony. That is the major distinction between what you're talking about occurred previously and now. I've heard the testimony. It is rather clear to me with reference to this offense. And that places the defendant in a very different position. And you know that, Mr. Burkett. Go ahead, I'll let you finish, but.
Well, it seems like you've already finished me, but what I'm asking for is, if you're gonna waive the bond, I mean, let's do something that's reasonable, Your Honor. I mean, these numbers that the prosecutor is throwing out, you know, it's something ridiculous, and he's doing nothing but punishing him.
And what would you suggest? Because quite frankly, the number I had in mind was much higher than what the prosecutor even asked.
Judge, he's been a perfect person since he got that bond. Never, I can see it.
I didn't ask all of that.
But
I asked the question. What are you suggesting?
Well, I'm hoping that you would let the bond stay where it is. That's my suggestion. Because I don't see the basis. These same charges, nothing changed in the charges since he was given that bond.
Anything else?
Nothing.
Having heard argument, court having heard testimony and clarity of the testimony, and with an understanding that the defendant is facing a life offense and it becoming clear to the court that that conviction may be very likely based upon this testimony, court is going to raise the defendant's bond, and the defendant's bond in the court, in doing so, now certainly at this point does consider the defendant to be more of a risk of flight than he was before, and also that the defendant, this court believes, does pose a significant risk. And I think, irrespective of the reasons that Mr. Burkett is in, I think that the bond, without anything else, the bond as set by the magistrate was a clear abuse of discretion from the get-go. So the defendant's bond will be set the amount of $50,000 cash as surety bond, dependent to remand. But I can't. Can we get Mr. Lee out? No, I don't. Oh, is he? Okay, great. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marie Chen, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry.
Mr. Rebo. Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Kwasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Probable sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Probable, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Probable has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
well,
Mr. Burgess may not have done.
And that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that, but I just wanted
Your Honor,
to make
if I
a
may.
record. What, could I just finish though?
Let her finish.
Mr. Lee
Sure.
indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted, and I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did my lawyer, did Mr. Burgess call you to try to, see if maybe if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with the.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quadley, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quadley not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. If it has gone to law enforcement now, and we can follow up.
Mr. Arabo.
Your Honor, as you know, I'm a defense attorney. I think it's Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how to slip between the cards, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant. What? During a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quasny, so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this, and it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody listen to it already.
Can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and court will listen to the call. I can give my decision.
You have to go back.
Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Prosecuting Attorney. I'm about people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Larry Lee.
Okay. The issue is in this case that, first of all, we're adjourning the hearing.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh,
I'm on the bench, but I'm not doing these.
Okay.
Set his preliminary examination July to defendant's request, so my next date is July 22nd, 2025, and that's another 12 p.m. start, because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
And I
me.
understand that.
And Mr. Lee is
I think
about jumping out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, and I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. You might as well stop right now.
I have the text
because
message.
no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
Pardon? I
Are you
am.
still on the record? You know, I'm not sure who this kid is or what he's capable of or what sort of messages you can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision in.
Yeah, one of those, Your Honor.
But counsel, why don't you let us know how you really feel? I know. All right. We'll
I
take
think the
care of that.
courtroom
And I'll add
I think
that
the
no
courtroom's
con- I'll
been
add
through
that
enough
no
today.
contact.
Thank you. Appreciate
Thank
it.
you, sir.
Take care. Bye-bye.
Thank you, Mr. Rubin. You ready? You got court calls the case of People versus Jerome Burns.
Good afternoon, Your Honor. Mary Tennis, attorney on behalf of you.
Where'd I can really go?
Find her.
It's like a squirrel,
It's only 4:15.
you know? And I had so much hope and promise for this day.
Assistant Public Defender, Tanavi Kiriakin, really, Your Honor, on behalf of Mr. Jerome Burns. Mr. Burns, state your name for the record, please.
All right. The record should reflect we had an in-chambers conference regarding this case, and this was set to go to their. And I'm gonna put it in this way. There is potentially some information that might be beneficial or exculpatory for the defendant, which the defendant has apprised his counsel of. Whether or not that exists or not, no. But there is a request that I adjourn this to allow counsel to explore that, as well as, because of where the information may be located, to fully explore and explain to her client the potential pitfalls of trying to obtain it in certain ways. I think I have said it. All right, so there's an agreement to adjourn the preliminary examination in this case. And my next date is not till the 27th, but because Mr. Burns is in custody, I'm going to give a special date of July 7th, 2025, hoping that that'll be enough time to accomplish what needs to be accomplished and not have him wait so long. July 7th, 2025 at 9 a.m. That's a Monday. And that's before me. All right, court does call the case of the People versus McLaughlin.
Public defender, Mr. Charles McLaughlin.
Hannah Mackey, hearing with and on behalf of Charles McLaughlin.
All right, very good.
Andrew Childers appearing on behalf of people, Your Honor.
All right. And this is a continuation of a preliminary examination, which I believe, I think it was Detective Rob was on a call that day. And
That's correct.
now he's here. And so you may call your next one.
Thank you, Your Honor. People would call Thomas Robb to the stand.
All right. Sir, please come forward to be sworn.
Take seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God? State, spell your first and last name for the record.
Thomas Robb, THRA.
Sir, thank you, Your Honor. Sir, how are you currently employed?
Detective with Washtenaw County Sheriff's Office.
And how long have you worked with the Sheriff's Office?
4 years.
Were you working in that capacity back on April the 15th, this year, 2025?
I have license as a road patrol deputy.
Road patrol deputy? Thank you. Directing your attention to around 7:30, 7:45 in the morning, were you in the vicinity of the West Willow neighborhood?
I was,
Okay, and on that date and time, what was your shift?
sorry,
What was your shift that day?
I was working day shift,
Okay, what time did you start?
8 a.m.
8 a.m.
I
Okay,
believe the 7:30 time was when the call initially came in.
okay. At some point, as your shift started, were you made aware of an investigation regarding a possible stolen Ford Explorer?
I was,
Okay, and who made you aware of that?
Deputy Phillips.
Okay. And what, if anything, happened in that morning on April the 15th that led to you being involved with that Ford Explorer in any way?
Deputy Phillips told me that he had taken a stolen vehicle report for that vehicle. He advised that he had gained GPS location for the vehicle from the victim. And I was pinging it, I believe, on Brookside, which was in the West Lowell neighborhood. He advised that he was going to go check the area for the vehicle and asked me to assist.
Okay. Were you and Deputy Phillips in the same patrol vehicle or separate patrol vehicles?
Separate.
Okay. To your knowledge, did Deputy Phillips arrive in the area of that suspected stolen vehicle before or after you?
Before.
Okay. How did you know that?
I heard him call it on the radio.
Okay. When you heard him call that out, where were you?
A few blocks away.
Okay. And what happened next?
After he called out that he was out with the vehicle, again, I believe it was on Brookside. I was a few blocks away. I heard mic clicks on the radio. That's pretty much when somebody depresses the talk button on the radio, but doesn't have a chance to get transmission out. In my 7 years of doing this job, normally when I hear that, that tells me that the deputy's in trouble, there's some kind of accident. That caused them to interrupt their transmission, whether they're chasing someone or fighting or something of that nature. So that gave me cause for concern. I continued towards that location where Deputy Phillips was at, and then I saw the, I believe it was 2024 Gray Ford Explorer. That was the vehicle in question, speaking out of the neighborhood.
So as you're entering the neighborhood, it's exiting the neighborhood?
Correct.
Okay. What did you do next?
I recognized that it was the vehicle we were looking for. I believe Deputy Phillips was in danger or something had happened, so I activated my emergency lights and siren to try to stop the vehicle.
Okay. And did you have to turn your vehicle around?
No, I was coming right at the entrance to the side street where the vehicle, the Ford Explorer, was coming out from. So
Okay.
driving directly at it.
Got it. And did you in fact then begin a pursuit of that vehicle? Okay. And that started in this West Willow neighborhood?
Yes.
Okay. What is the speed limit on the road there where you initiated this chase?
It's a residential neighborhood, so 25 miles an hour.
Okay. Did the vehicle pull over after you activated your overhead equipment?
No.
Okay. What happened next?
The vehicle accelerated and tried to evade me.
And did you continue to pursue the vehicle?
I did.
And for how long did you continue to pursue this vehicle before it was eventually stopped?
I believe about 10 minutes or so. I don't recall exactly the time.
Okay. Where during that time, do you know, Detective Rob, what speeds did you get to?
I believe maximum speed was about 130 miles an hour.
130?
Yes.
Okay. What sort of vehicle were you in?
A Ford Explorer.
Okay.
It was a fully marked patrol car.
Thank you. At what point did this chase terminate in any way?
Van Buren Police assisted us with the pursuit. It was a Van Buren officer deployed stop sticks, which the stolen vehicle ran over, which caused, I don't know if it was one or multiple tires to deflate, and then the vehicle crashed into a berm at the entrance to a neighborhood. I believe it was on the end of any forest roads.
And that's in Van Buren Township?
I believe so.
Okay. From the time period that you started this pursuit in the West Willow neighborhood to the time that it ended in Van Buren Township, did you ever lose sight of this Ford Explorer?
No.
Okay. After the vehicle was hit the stop sticks and crashed into the ditch, were you able to determine if the vehicle was occupied?
Yes, I was.
And were you able to see anyone in that vehicle?
Yes.
Okay. Are any of the individuals that you saw in that vehicle on April the 15th in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
Yes, it was Giles McLaughlin. He's sitting to my left wearing a green jumpsuit.
And where, Your Honor, may the record reflect in court identification of the defendant?
Without objection, record show so reflect.
And where in the vehicle did you observe the defendant?
He was exiting the driver's seat.
Okay. Was there anyone else in the vehicle?
No.
And what did you do at that point when you made contact with the defendant in the driver's seat of this vehicle?
He was exiting the driver's seat. I told him to show me his hands and get on the ground. He did. I placed him in handcuffs.
Okay. Did he appear to be injured in any way?
I believe he had some scrapes or bruising on his arms. Maybe, I think he might have had a small amount of blood on his lower lip, if I recall correctly.
Okay. Is it, do you recall, did like the airbags deploy in this crash?
I don't recall.
Okay. I have no further questions, sir. Thank you.
All right, thank you. Cross-examination.
Good afternoon, Deputy Rob. You were in pursuit of the vehicle in question?
Yes.
And you followed that vehicle for around 10 to 15 minutes?
Around there.
And during that time prior to the accident, you got no closer than 50 feet, did you?
I got no closer
To
than,
the vehicle than 50 feet, would you say?
I don't know how close I got during the pursuit. I guess 50 feet might be accurate about closest I was, but I don't recall without reviewing the camera footage.
And you testified on direct that during the course of the pursuit, you activated your sirens. Is that correct?
Yes.
And at some point you were driving on the highway?
Yes.
Was it a busy highway?
I would say there was a medium amount of traffic.
So that means that there were other cars on the highway during the pursuit.
Yes.
And you had to make several lane changes to navigate through that traffic, didn't you?
Yes.
And some of those cars pulled to the side. Is that correct?
I'm sure some of them did. Well, usually people play not very good about pulling over.
And it would be safe to say then that some cars did not pull to the side? And at one point you had to even drive on the shoulder of the freeway, is that correct? You don't know why some of the people did not pull over to the side, do you?
Well, without talking to them personally, no, I wouldn't know why.
So you don't have any personal knowledge then as to whether or not the drivers of those vehicles could hear the sirens?
I suppose so, yeah, without talking to them.
So then it would be fair to say that you didn't know why those vehicles did not pull over?
I guess so.
And you don't have any personal knowledge that Mr. McLaughlin could or could not hear the sirens, did you?
I suppose not.
Thank you, Your Honor. No further questions.
Right, can you redirect?
No, Your Honor, thank you so much.
Sir, thank you.
Thank you.
Your Honor, with Detective Rob's testimony, the people have no further witnesses, the people press.
Any witnesses for the defense?
None for the defense, Your Honor. Thank you.
All right.
Now, people would move to bind the defendant over as charged on the information before the court. I believe it is 5 counts, yeah.
Yes.
5 counts.
Mr. Brown responds.
Thank you, Your Honor. Your Honor, the court listened to the testimony previously from Deputy Phillips. It also heard the testimony from Deputy Rob. So the counts that we have that the prosecution is requesting for bind over are assault with intent to murder. That would be on Deputy Phillips. There's fleeing and eluding. That would be on Deputy Rob. There's receiving and concealing a motor vehicle, an unlawful driving away, and a resisting and obstructing causing injury. And I think that last one goes to Deputy Phillips. So I know it's been a bit, so we probably should go over what the prior testimony was. The testimony from the Deputy Phillips was that on April 15th, he was on road patrol. He'd gotten a call that a reference a stolen vehicle at the Marriott. He responded, had contact with the owner. The vehicle described as stolen was a gray Ford that was stolen sometime during the night. I don't know if we ever really narrowed that down to exactly what time that vehicle would have been stolen. That was entered into lien. At some point, they got to the cul-de-sac in West Willow where the GPS told them that the vehicle would be found They first got there, they couldn't see the plate because the vehicle was facing them. I believe that when they pulled up, they were facing the vehicle. They're probably 20 to 30 feet away from the vehicle. Again, it was facing them. And while they may not have been directly head on, they were in front of them with their headlights facing each other. The officer testified, Deputy Phillips, that he could see that there were at least two people in the vehicle at the time, that they pulled up. But then once they came to a stop, they said they were going to conduct a modified felony stop. Deputy Phillips said he unholstered his pistol. Two passengers then got out. And so two people got out of the vehicle. And they started walking away from patrol car as well as the vehicle that they were in. Said he couldn't see the driver at first. Later could see who the driver was at about 15 feet. Said he yelled to the driver to turn the car off. So I believe the car was still running at this time. This point, his weapon is drawn. He says that he stepped out away from his vehicle into a space. This is a cul-de-sac. And as the testimony was developed, there was a space between the front of his vehicle, where he was the passenger, got out, and a space in the street from where a vehicle could pass through. He said he got out, couldn't recall whether or not he'd raised his hand, but he did get out and he got into that space. He said he could see the vehicle, the wheels turning, and that the car then drove at him without veering. He had his weapon drawn, and the vehicle, once it got started, did not stop, drove at him, clipped him on the knee as he had to jump to move to get out of the way of the vehicle. He did say that the vehicle does not stop after that. I asked him if the driver said anything to him. He said that there was nothing said, no threats made or anything like that. He did say he had recognized the driver as Mr. McLaughlin. He then testified that he and his partner then got into the vehicle and left in pursuit. So what we have then is the vehicle stolen sometime in the night. We do not know, or there was no testimony given as to who drove that vehicle away. We do know when the vehicle is seen again, there are 3 people in the vehicle. And I'm not clear as to how much time has passed. It's been a few hours. So we don't know if the person who took the vehicle, drove the vehicle away from the scene, is even in the vehicle when it's reached at West Willow, because there's been no testimony given for that. If the court remembers differently, certainly they could say, but as I recall the testimony, they spoke with the person who owned the vehicle and they simply said that the vehicle was taken in the night and they had a GPS and they're able to track them. So at the time that the officers or deputies are looking for the vehicle, tracking the vehicle, they have no idea who has taken the vehicle, male or female, white or black, fat or skinny, tall or short. There is no description of the driver or the person who actually drove away with the vehicle. We just don't have that. But what we do have is 3 people who are associated with the vehicle. 1 person is in the driver's seat, and several hours that have passed since the vehicle was driven away from the spot. So let's go back to the first charge, which is assault with intent to murder. So based on Mr. Chalice McLaughlin driving at the officer who was in the space to which the vehicle must pass in order to leave the scene, based on him driving at the officer and hitting him, the prosecution is charged assault with intent to murder. Now, most of the time we see this is usually charged as felonious assault. In fact, every time I've ever seen this, it's been charged as felonious assault. And there is a reason that it's charged as felonious assault. First, in order to prove assault with intent to murder, prosecution must show evidence which would have supported murder had death occurred. And that's first degree. They have to show that it was a first degree murder because they have to, in this backup. This is People versus Sis Medea. That's 167 Mish 210. They have to show that that murder, that had death occurred, it would have been properly charged with murder. So, second, let's go with People versus Todd, 186 Mishap 625, 1980. There must be an intent to kill in order for you to have, for murder. For you to have murder, there must be an intent to kill. And this is what the prosecution is no doubt going to argue. They're going to argue, you know what, even if he didn't say, I'm going to kill this guy, I plan to murder this guy. And you have to have that. You have to have plan and motivation to murder. They're going to say, well, he created a risk so high that, and he knew the consequence. He knew if he hit this guy, he could die, that's going to be sufficient. And I think would be the logical thing to argue, that the risk that he created with the knowledge of the probable consequence, that'd be sufficient. But the law would not support that. People versus Milton, 81 Mishap 515, 1978. There must be some time for premeditation and deliberation. So remember, the court may recall that it was 6 seconds from the time the officer got out of his vehicle and stood in that area in order to stop this vehicle from leaving. 6 seconds. Now, the law does not define how much time you need for planning and premeditation. It doesn't do that. But it is clear where there is no evidence of planning and motivation. They have to show that. They have to show some plan, some motivation to kill this person. What you've seen is a motivation to leave, to flee the area, perhaps. But there is no evidence put before this court that when this vehicle was driven at that officer, that the plan or the motivation, the intention or the premeditation was to kill anyone. And they have to show that. It's not enough that they show, well, it's likely.
But isn't that really a question of fact?
No.
As to whether or not.
Good question.
Evidence is sufficient.
Good question. Because People versus Oster, 67 Mishap says, where there is no evidence of planning or motivation, bind over is erroneous. So no, it's not a question of fact. And it's a great question, but People versus Oster has already answered that for us.
You've already said, have you not, that even though it's a 6-second time frame, that could be, or a fact finder could conclude that that is sufficient time for the premeditation. Right?
Thank you. I've not said that.
Well, I know you're not saying that, but you are saying that the case law does not indicate that de facto says that there is not enough time, because the time frame is not spelled out.
Right, the time frame is not spelled out. That doesn't automatically mean that it's an issue for the trier of fact, because they still have some duty, Your Honor, to show that there was some planning and motivation. That's what you're giving, what you would, if you were to bind over based on what you have here, you'd be taking away their duty. You'd be relieving them of their duty to put that evidence in, and that's what they have at preliminary examination. They have a duty to show that there was some planning. You can't simply say, well, you know what, since the law says that, there's no time frame, then that's enough. They have to actively show that there was a plan of premeditation to murder. It's not simply, well, you know what, and again, if you couple that with People versus Milton, where even the creation of a high risk of death with knowledge of the probable consequences is insufficient, that makes their duty very clear, Your Honor. They can't simply just toss these things out without showing exactly what they need to show, and that is that there must be some premeditation, some plan to do so. They have an active, affirmative duty to show that. They simply can't say, well, what he did was risky, and that's enough. They can't say, well, since there's no time frame, that's enough. They have to show you that there was a premeditation and a plan. And the most likely thing that was going on here was Mr. Jackson was trying to leave the area. The officer got into that area, and in the 6 seconds that it got for him to get out of his vehicle and to walk into that space where the vehicle had the only space where they could get by, and they ended up hitting him.
Premeditation necessary for first-degree murder implied where it involves a police officer?
There's no exception for police officer. There's no police officer exception.
No. But where it becomes first-degree murder, it's implied. Because there are certain types of acts that constitute first-degree murder.
Right.
Right? One of those would be the potential killing or the killing of a police officer. Where the premeditation is implied.
So you're saying there is an exception for police officers with acts that
I'm not saying it's an exception. I'm just saying there are certain things that will constitute implicit premeditation from the standard definition.
So you're saying that there is a police officer, something that specifically.
I don't know if you want to call it an exception. I'm saying that there's something unique as to police officers, such as it would be where murder occurs during a first-degree CSC.
That's a felony murder consideration, Your Honor.
Well,
and I don't.
Well, it can be, it can be that. But even when you're talking about it being murder, what you're doing is you're implying the premeditation necessary.
Because it's a police officer, so what you're saying in some clear. I
asked the question, isn't there an exception?
I do not believe there is. I do not believe that the law changes. And you know, that's equal protection. My client is entitled to equal protection under.
I don't think it has any equal protection implication. It's just a question of whether or not under the statute that gives that there is an exception.
Well, it is.
You're calling it an exception.
It is equal protection in that my client is entitled to, and again, I don't believe that this exists. Certainly, we can research it if the court believes that actions.
I just asked the question.
Well, okay. So my response is, I do not believe that that is a thing. I do believe that that's a thinking and charging what in every other case is always charged as a felonious assault. I do believe that there's a thinking, and that's where the equal protection comes in. That's exactly where the equal protection comes in.
I don't know.
Because my client is.
I don't know if that's equal protection.
Well, I'll explain to you why I think so.
Well, I don't need it.
Okay.
Because I don't think
you've rejected it up front. Okay, fine.
I rejected it outright.
Okay, all right, fine. Well, Your Honor, then I have to say I reject the notion that police officers have some sort of protected status.
Well, you could reject it. I asked the question. You're saying
Okay.
no.
I'm saying
I'll
no.
hear from the
I'm
people
saying
when they get
when
to
they get there. Okay, all right. So let's move past that. Let's go to the unlawful driving away. Now, as I recall the evidence coming out, and the court may remember differently, there was no identification of who drove that vehicle away. And for unlawful driving away, the person who drives the vehicle away or.
Yeah, but yeah, I hear that argument, but it doesn't matter whether it was driven from the scene or from the hotel. Is it really going to matter?
Yes, because one is receiving and concealing stolen goods and one is driving away. The thief has to drive the vehicle away. If they put no evidence before you, let me back it up. Sure, you can certainly say that recent possession of stolen goods leads to the inference that a person knows the property is stolen. It does not lead to the inference that the person stole the property. And they have to put evidence on that Mr. McLaughlin drove that vehicle. That's why it's called unlawful driving away, Your Honor. It's not unlawful possessing later on. It's unlawful driving away. You can't conflate receiving and concealing with unlawful driving away. They have a duty
Well, the person, so what I'm saying is whether or not he took possession at the hotel or whether or not he took possession at the cul-de-sac, because he was driving the vehicle, and there's testimony to that, he took possession and he's driving it away.
That would be at most unlawful, that would be receiving and concealing stolen property, Your Honor. Unlawful driving away means that he has to have taken the property knowing that the property was not his, that he was taking the property from the owner. You don't know that he was at the hotel. You can't, and that's.
I'm just saying it won't matter where you start, though. I'm not saying that there's an indication that he necessarily took from the hotel. If you concede that point, I'm saying the unlawful driving away can happen at the point of the cul-de-sac.
Then how do you get on receiving and concealing stolen property? How do you distinguish the two if you're going to say it's always a?
I'm not here for reasonable doubt. I'm not here to answer your questions. So you can go ahead with your argument.
All right, so let's make sure that we're clear on that. Unlawful driving away demands that the person take the vehicle, take possession of the vehicle, in contradiction or in contrast to the owner. If he takes possession of the property from someone else who stole it, he's not an unlawful driver away of a vehicle. He may be someone who receives and conceals. The problem for the prosecution's case, Your Honor, is they have not established who took the property from the owner, or at least where the owner had the property last. And they have to do that. Just because you can say that he was in the vehicle later does not and cannot support a UDAA. At best, it can support a receiving and concealing of stolen property if you go with the thought that recent possession of stolen property, knowledge that the property itself is stolen. But it does not support a claim that the person, whoever is in possession of it, actually took that vehicle. And that's what UDAA demands. They have to have taken the vehicle from the possession or control of the owner, even though it's in the parking lot and the owner may be elsewhere. They have to have taken it there. If they drive it later, at best, that's a receiving and concealing. It's not a UDAA. That's not what the law says for UDAA. If you argue something differently, then always, if someone steals the car, hands me, and that's another thing too. There's not been any evidence put on that my client had the keys or didn't have the keys. But even getting past that part, and getting past the notion that someone may have given him the keys elsewhere, I can concede that it's relatively recent possession, even though we don't have enough time, or we don't have a specific time period, how long the vehicle was taken or when my client would have come in possession of that vehicle. And that's important when he comes in possession. If someone else steals that vehicle and hands him the keys or hands him whatever, you cannot say that he drove that vehicle, like that he unlawfully drove the vehicle away, because that has to come in against the owner's possession and control, and not against someone or anyone else's possession and control. We don't know that any of the other two passengers didn't take that vehicle away, at least not from the evidence that's been presented here, that any of the other two passengers didn't take the vehicle and then give him possession later on. And that's important. So, with respect to the 2, 3, and 5 counts 2, 3, and 5, I believe that those are in fact issues for the trier of fact. With respect to count 1, I don't believe that the prosecution has met its burden of proof. And if the prosecution can get up and say that there is an exception for police officers, as the court suggests, and they can cite some case law.
I asked the question, Mr. Brown, so don't put words in my mouth.
I won't.
I'll hear from them.
All right, fine. So, and also with the UDAA, I don't think they've met their burden there.
Response.
I'll start with the assault with intent to murder. So looking at the jury instruction 17 and Michigan pattern criminal jury instruction 17.3, assault with intent to murder requires the defendant try to physically injure another person. Second, that when the defendant committed the assault, he had the ability to cause an injury, or at least believe that he had that ability. And third, that the defendant intended to kill the person and the circumstances did not legally excuse or reduce the crime. Intended to kill the person, not intended to commit first-degree murder. That's a very different thing. And looking at People versus Erickson, a Michigan Court of Appeals published case 288 Mishap 192, this is from 2010, specifically states this points to this jury instruction as the elements of assault with intent to commit murder. It is not assault with intent to commit first-degree murder. It's just assault with intent to commit murder.
So I don't even need to address that issue, whether there's an exception premeditated.
There's nothing in the jury instruction that
requires that. Okay.
And so then we're left with the question of is the defendant in driving a Ford Explorer at Deputy Phillips intending, can you infer from that behavior an intent to kill? And the argument before the court that the people would put forth is when you're piloting what is probably a 4,500 or 5,000 pound object, accelerating and pointing that vehicle at an individual, you absolutely, that those actions, there's a logical inference that can be argued that would create a question of fact that you're intending to kill that person. That's a mass, we're not talking about a motorcycle or a scooter or a golf cart or anything else. We're talking about a Ford Explorer. This is a large vehicle. The defendant looked, based on the testimony of Deputy Phillips, he was looking right at him. Deputy Phillips is attempting to get him stopped. He steers in the direction of Deputy Phillips, hits the gas and hits him. Now, granted, Deputy Phillips was able to get out of the way, and it only struck his knee and kind of fell to the ground. But we have to consider the actions of the defendant, and I think to a probable cause standard, there is certainly a question of fact as to the defendant's intent. But unequivocally, if you take a Ford Explorer and you floor it and you aim it at someone, you can kill them. That is just common sense. Regarding the UDAA, again, relying on the jury instructions, unlawful driving away out of automobile requires first that the vehicle belonged to someone else. Second, that the defendant took possession of the vehicle and drove it away. And third, that these acts were both done without authority or without the owner's permission. Fourth, the defendant intended to take the vehicle without authority, knowing that he or she did not have the authority to take the vehicle and drive it away. As the court alluded to, that doesn't require that you must take the vehicle from the first place it was stolen. Now, I think that there's a logical argument and facts such that the location of the hotel versus the location of where this vehicle was found and the time frame that it happened at some point overnight, and this is 7:30, 8 o'clock in the morning. Again, there's a logical inference, circumstantial evidence to suggest that the defendant did in fact take that vehicle from the hotel parking lot. We're not talking about one state over or 200 miles away, something to that effect. But I believe that, again, there is sufficient evidence before this court to a probable cause standard that there is a question of fact regarding that count. And I believe that it should be bound over on all 5 counts.
All right, okay. With reference to, there is no dispute as to a bind over on count 2, 3, and 5. Therefore, the court also does believe that the people have sustained their burden and the defendant would be bound over on counts 2, 3, and 5 without objection as they raise issues of fact. In terms of the unlawful driving away of a motor vehicle, again, it would be this court going into the province of the jury as to when they first saw the defendant in the vehicle. Certainly a jury could reasonably infer from the hotel, the timing and everything else that it was indeed the defendant to do that. I don't think that people have to go beyond that. So certainly under that, if the theory is correct that it's got to be taken from the location from the owner, but I don't think that that's correct. But still, even then, I think a reasonable fact finder could conclude that. As it relates to the other piece of that, I think an individual can be charged with the unlawful driving away of a motor vehicle when they took possession or assisted in taking possession of that vehicle. I don't think it excludes, it doesn't get charged or can't be found to the exclusion of something else, a receipt and concealment. Certainly a reasonable fact finder could conclude that the defendant did, even at that location, take and or assist in the taking of that vehicle and its unlawful driving away. So that charge would be proper, and a fact finder could conclude that. So the court would bind the defendant over for those reasons on count 4. With reference to count 1, the assault with intent to murder, I also do not believe that it requires first-degree murder and some premeditation within that. It is really the intent to kill, as the instruction indicates. But even though I do believe that if it were to require that, I think that premeditation is implied within the actions of the defendant because of what was happening, and there's no equal protection argument regarding that. However, very clear in the testimony where a reasonable fact finder could conclude the intent was Deputy Phillips' testimony that as he's there, the wheels of that vehicle are pointed right at him as it's accelerating out. It's not a circumstance where they were trying to go around him, they were trying to do whatever. And certainly a reasonable fact finder could conclude that that was an attempt to strike and kill Deputy Phillips. And that, as it then relates to count 5, maybe by the grace of God, Deputy Phillips gets out of the way. His leg is hit and injured. But that would, even though he's able to do that, that doesn't necessarily negate the intent that the defendant, or what one could find as the intent to kill in this case. And the court believes that there is sufficient evidence as it regards that under either theory of the first-degree murder or under the notion of kill. I think there's sufficient evidence to go forth to a jury on that charge, and therefore the court would find that the people have sustained their burden and bind the defendant over on count 1. So to conclude, the defendant will be bound over to stand trial on all 5 counts. Now that you see the information, waive it to reading.
Yes, sir. Now that you see the waive it reading for the record, I'm going to enter a plea not guilty.
And having waived formal reading, pleading not guilty as to all counts, court will enter that plea. Pretrial will be set for
August 13th, 2025 at 1:30 with Judge Conlon.
August 13th, 2025, 1:30, Judge Conlon. Bond will continue. Thank you.